right there. I have Paul Rice. He's in the jail.
Okay, well, they haven't called in yet. As soon as they do, we'll get started.
Okay, thank you.
Mr. Javante Jones, don't hang up. I'm probably gonna get you a date. Your attorney's in federal court, but I still want to move your case along, so hold on before you log off.
Okay.
Attorney Chambers, good morning.
Good morning, Judge.
Ready to call your case? Are you ready?
Yeah, I'm ready. Thank you.
Okay. It's not on the docket. It's the 10 defendant case. I need to see.
You said, I'm sorry, you said Larry?
Yeah, I'm just gonna call the case. Wait.
Martha, would you happen to have the case number?
23
Okay.
055-480. Okay, oh wait. Okay, we're on the record as the people of the state of Michigan versus. Right then. Attorney Chambers, what's your client's name?
Deshaun Perry.
I don't know why I had copies. I knew Gary. Yeah, thank you. You did it too.
Well, you in it.
Okay. We're on the record as the people of the state of Michigan versus Sean Malik Perry, 2355480. Mr. Perry is defendant number 2 and charged with count 1, possession of weapon in jail, and count 2, police officer assaulting, resisting, and obstructing. Today is the date set for I believe, a dismissal appearances.
Alexander Kirker on behalf of the people, P862282.
And good morning, Judge Arnie Chambers on behalf of Mr. Perry, P number 63956.
And is it correct? I did receive a dismissal form. Is that how the parties are moving forward today?
My understanding, Judge, yes.
Okay. All right, I will sign it and I am dismissing this case without prejudice per plea that your client is taken over at Third Circuit.
Thank you.
And I'm waiving your client's presence today.
All right, appreciate you. Thank you, Judge. You have a great day.
day.
Yeah, Judge, could I get a copy of the signed dismissal email to me? Is that possible?
Yeah, we'll have a scan.
Appreciate it.
You're welcome. You have a good day.
You too.
I did print out a copy.
I'll sign it for you. Okay. Attorney Roberts?
She said it was ready to change. Thank you.
Okay, just in case. You can get it from there.
Thank you. Oh.
Devontae Jones,
Yes.
have you had communication with your attorney?
Yes.
I can't hear you. You have to speak up.
Yes.
Okay, I'm adjourning your probable cause conference to tomorrow since your attorney decided that, he wasn't coming today. Okay,
You said till tomorrow?
tomorrow at 8:30 sharp. Tell your attorney 8:30 sharp on Zoom.
Okay.
And you'll be on Zoom as well. You do not have to come in person. 8:30 tomorrow for your PCC.
Okay.
Probable cause conference.
Okay.
All right, you're all set, Mr. Jones.
All right.
Trooper, I'm going to say your last name wrong. How do you say your name?
Kaya, Butch Kaya, good morning.
This guy, good morning. Are you here for a traffic matter?
Yeah, Sade Jones.
Okay, so Judge Larry Williams is handling traffic now. This is the felony courtroom. I'm gonna put the information on the screen so you can see where to go. This courtroom is 322.
Let me take a picture. All right, thank you.
You're welcome. Have a good one.
You too.
Anybody ready for their cases to be called? In person, on Zoom, anyone?
Apologies for the wait, Your Honor.
That's fine. Sure you're busy enough to work on. Ready on your client cases?
Yes, Mr. Ellie is present.
Okay, let's start with Mr. Ellie. Mr. Ellie, unmute your device. You're on the phone, so you have to hit *6.
I think he was having trouble connecting.
I keep cutting off the video.
I didn't understand the restaurants, but I think it was time.
Mr. Ellie, hit *6 on your phone. Nope, didn't work.
And Your Honor, if it's easier, I'm just expecting to do scheduling an examination date. if we could just waive his presence constructively for the purposes of doing that, since he can hear us.
Wonderful. Okay. We're on the record as the people of the state of Michigan versus Wilbert Lewis Ellie, 2355427. Mr. Ellie is charged with count 1, police officer fleeing, forfeit vehicle code. Count 2, police officer assaulting, resisting, and obstructing with the habitual offender fourth offense notice set for a probable cause conference today. Appearances.
Alexander Kirker on behalf of the people, P 86282.
And good morning, Your Honor, court staff, Jonathan Roberts, P 86428, on behalf of Mr. Ellie, requesting that his presence be waived for the purposes of this proceeding.
Okay, and he is on Zoom. I see his face and he's logged on another device that will not unmute. So I will waive his presence as he cannot speak, but he is present.
Thank you, Your Honor. And I do believe there are 2 cases. I don't know if you want to call them at the same time.
Thank you. I just realized that. Mr. Ellie is also charged on case 2355762. And on this case, he's charged with 1 count of controlled substances, possession, cocaine, heroin, or another narcotic less than 25 grams with the habitual offender fourth offense notice. And Attorney Roberts, is it correct on both cases you're ready to set exam date?
Yes, Your Honor.
Okay. Would you like them both on the same day?
If possible, yes, thank you.
How about March 16th at 9 o'clock?
I believe that should work. I want to say that I will be appearing in front of Your Honor that day at 11 a.m. anyway for a different matter. So,
Yep, I have you on at 11.
okay. So the 16th, let me just double check. So on the 16th, I will be in Judge Jefferson's at 9:15. If possible, could I be scheduled for 10 o'clock, 10:15 on the 16th?
Yeah, it'll be a little, so the 10 o'clock scheduled already at 2 10:30s. So
Okay,
it might be a little clogged up. Of course, we'll handle everybody. But the morning really
Of course.
starts at 10 o'clock on that day.
okay.
You wanna do
So
the next
if
17th?
the 17th should work, do you have availability at 11? I just have sentencing at 9:30 and 10.
Yep, that works. March 17th. And
Thank you.
schedule both of them for the same time.
Okay, thank you.
And Mr. Ellie, I know you can hear me, but you can't respond. Your preliminary examinations have been scheduled for March 17th at 11 a.m. in person at 36 District Court.
Other, because then whoever wants to be.
Okay, anything else for either party?
Nothing for the people, Your Honor.
Nothing from defense. Thank you, Your
All
Honor.
right, have a good day.
You as well. Thank you. And Mr. Ellie, you can log off now.
Plan, and I said, you put question about that, and I kind
Whose
of.
background noise is that?
Bring the keys downstairs to the basement, you know what I mean? So you know, everything downstairs.
Okay, Melanie T. To the gentleman logged on with RGUTI, can you unmute your device and state your name, please? To the gentleman eating right now, can you state your name, please? You're on mute. You're muted. You have to unmute your device.
Oh, hello. Yeah, my name is Roy. I just logged in to see the case with what's the name of this guy? With Paul the arsonist.
Is this the landlord tenant case?
No,
What
this
type
is
of case?
criminal. This is criminal. Paul Rice.
Oh, okay. And
I didn't think anybody was going to see me. I just called to watch, and I definitely wanted to.
your name is
I wa-
Paul Rice?
I'm sorry.
What is your name?
My name is Roy Gutierrez.
Okay, what is your involvement with Paul Rice?
Well, he burned my house, and I know he's coming up for, I guess, a second meeting with you, and on my behalf and behalf of the whole neighborhood, we
Judge,
just
I'm going to object to this person speaking. I'm Paul Rice's attorney. I don't think he should be directly addressing the court about any alleged facts of the case.
You're at this point, we haven't even scheduled for testimony, so if you're to testify, I will hear what you have to say at that point. The prosecutor manages that. So,
okay, no problem.
today
I'm
we're
sorry.
not having testimony.
Yeah, I had no idea you guys were going to see me. I just logging in to watch what happened with his case and make sure he doesn't get out. But I apologize for that, Your Honor.
That's okay, so you can log on YouTube and watch without being in the Zoom meeting.
Oh, okay. Got it.
Yeah.
Got it. Thank you very much.
You're welcome. Good morning, Attorney Washington.
Yes, good morning.
How are you today?
I'm doing fine. How are you doing?
Pretty good. Who are you here for?
I have Darnell Black for a PCC.
Okay. He's been logging on and off with audio issues.
He's here, ma'am.
He's in person.
Yeah.
Oh, he's in person.
Yeah, he's.
Oh, he's in
in the hallway.
person. Okay.
That's fine. You can bring him in.
He left and then logged in.
Okay, so he left, but he logged in. So he at least was present.
Okay.
Have you had any communication with him?
I haven't, and if he logs in, if I could speak to him in a breakout.
Okay, I don't know if he's gonna log back in anytime soon. I don't know what he's doing.
He's having issues.
Okay.
Okay.
Do you want to call his case, waive his presence, and then if he logs on, I can give him your contact information and have him call you,
Yes. Uh-huh.
so you don't have to wait on Mr. Black?
Okay. All right. Thank you.
Yeah. Okay, we're on the record. This is the people of the state of Michigan versus Darnell Deontay Black, 2260478. Mr. Black is charged with 1 count of robbery armed with an habitual offender's second offense notice, set for a probable cause conference today. Appearances.
Good morning, Your Honor. Daniela Parrish on behalf of people, P85495.
And good morning, Your Honor. Earl Washington, Neighborhood Defender Service, P31383, on behalf of Mr. Darnell Black.
And Mr. Black logged on to Zoom, and my court officer said that he was in the hallway, but he left to go log back on, and he's having audio issues. So if you're okay with waiving his presence, I am as well.
Okay. I am, Your Honor.
Okay. And I will also provide your contact information to Mr. Black once he logs on.
Okay. Thank you.
So are there any discovery issues?
If I could check that. Yep, I appear to have the paper and the digital.
Okay, you ready to set an exam date?
Yes.
Okay.
He had 2 cases so far. Thank you.
I have Thursday, March 16th at 9:30 available.
Yeah, that appears to be a good date and time.
Okay. So I will once again let your client know if he logs back on his date as well as your information, contact information.
Okay. And what time is that again, Your Honor?
I'm sorry, 9:30.
9:30. Okay, thank you.
You're welcome. You have a good day.
You have a good day to you and your staff.
Thank you. Okay. This is Evan.
No, this is Mr. Lauren.
8:30. Okay. You're on the record as the people of the state of Michigan versus Nico Amos Lorick, 2355662. Mr. Lorick is charged with count 1, police officer fleeing second-degree vehicle code, count 2, police officer fleeing third-degree vehicle code with an habitual offender's fourth offense notice. Today is a step for preliminary examination. Appearances.
Alexander Kirk on behalf of the people, P86282.
Good morning, Your Honor. Nancy Becker from Neighborhood Defender Service of Detroit, appearing on behalf of Mr. Nico Lorick, number 80549.
And Mr. Lorick, can you state your name for the record?
Nico Lord.
Okay, everybody ready to proceed?
Your Honor, just a quick matter in regards to the video discovery in this case. I was in trial and my co-worker had stood in for me at the PCC. We did not have the digital discovery at that time. She did make a request for it. Yesterday, I found out from my office that we did receive the body camera from the arresting officer, but we did not receive the dash camera. And then I do remember her putting in the notes in the file that, she asked if it's not available, if we can be provided with a reason for its unavailability. So I'm not sure why we don't have the dash cam in this case. It is relevant in this case, given that this allegation is for blatantly eluding. And the police officer is alleging that he observed a vehicle that was speeding and that, he proceeded behind it. So I do believe that it is relevant for us to have the dash. So,
Mr. Parker, any knowledge on the dash cam?
No, Your Honor, at this time I'm trying to pull up the videos right now, but it's taking a while on my laptop. The officer in charge is here. You'd like me to go ask him?
What's his name? Have the officer call, or is he already called? There he is. Is that the officer? We're off the record on this case. Mr. Black? Mr. Darnell
Yes.
Black?
Yes,
Okay, I understand you had some audio issues.
yes. I'm
Okay,
sitting in the
you're-
hallway.
Okay, so your attorney logged on and set your exam date, and he wants to speak to you. Do you have his phone number?
No,
Okay, so let me give where are you? Are you in the courthouse?
I'm in the hallway.
Okay, just log off and come inside. I'll give you your court date and his attorney's information in writing.
Okay.
Okay, back on the record. Mr. Parker, any information, OIC?
No additional information other than just simply the videos were uploaded, but it's not clear which ones exactly were uploaded in this case.
Is there dash cam?
The officer in charge isn't sure.
So everything that you have has been uploaded?
Yes, and sent over.
That's how you look through everything.
Yes, Judge, and I don't usually, the Detroit police officers' vehicles are. Usually the police Detroit vehicles are equipped with dash cams. So I don't know why we don't have a recording of this. And again, Judge, I do believe that it's relevant for this particular case, just because due to the nature of the charges.
I just need to know if it exists. Mr. Parker, officer in charge, what's your name, sir?
Morning, Your Honor. I'm Sergeant Matt Foltz, that's spelled Fulks. I'm standing in for Officer James O'Shea, who was the OIC. Unfortunately, he wasn't able to make it, and we have to make sure that somebody shows up. The only thing that's written on his investigator's report, that all available footage was uploaded. It doesn't say in his investigator's report what that video is. Yes, our scout cars are equipped with dash cams. However, there's always problems with uploading and just it's a fickle system. Sometimes we just don't get it. But all available video I know was uploaded because it's in his report.
Okay. Ms. Castro, you still standing? I'm sure that you want to know if it exists.
I do, Judge, because in order for me to, effectively represent Mr. Lurie, I would need all the discovery in this case. Again,
Well, not necessarily all the discovery right now at the exam, because it's ongoing, but the dash cam, see that the charges are, the dash cam would help.
I would
As far as
yes.
what's your case, right?
Yeah,
Or hurt your case, you don't know.
well, Judge, right, because I haven't seen it, but again, if I'm going to be cross-examining the witness, I would need to have that information in order for me to properly cross-examine the witness and, either corroborate or not corroborate what this testimony is.
Sergeant Folks, I know you're standing in, is the other OIC coming back, or are you on this case moving forward?
No, he'll be coming back. I'm just the temporary OIC for today.
Do you think you will have more information as to whether a dash cam exists?
No, Your Honor, because we do several arrests every day. So these cases all just end up blending in. Basically, somebody in the office every day handles all the video uploading for what's ever available. Sometimes we have body cam, video footage that's not available. It didn't upload, it didn't record. Same thing with dash cam. But everything that we do have gets uploaded into the database that the Wayne County Prosecutor's Office has available to us. So if it's not in there, it means it doesn't exist.
Thank you.
Yeah.
All right, Ms. Castro, I can't require the police department or the people to produce something that doesn't.
Understood, Judge. Your Honor, if the court would sign an order into looking into why it doesn't exist, because again, we do need an explanation, just saying that if, you know, there might have been a malfunction, knowing that their system is or has the potential of having that done, then that means, you know, there would be more. You would assume that they would be more careful in making sure that all the video discovery is being uploaded properly and not just knowing that the system is having issues and just kind of overlooking it. That is concerning.
And I'll tell you, I will sign for it.
Yeah.
About the traffic division, there's a lot of responses that video was not uploaded, and I requested answers from the law department, police department. It became a big issue. So I don't know if we'll get an answer based off of me signing the order, but it was a very unpleasant case based off our.
I mean, Judge, I don't know, as his attorney, as Mr. Lord's attorney, I need to be able to find out why something doesn't exist if it is part of evidence. And so, I'm sorry, can you speak up? We would need more information as to why this information does not exist, knowing that the vehicles are equipped, knowing that there is a possibility that there has been, you know, technical issues with uploading it. That wasn't notated in the paper discovery. So I think right now we're just going off of assumptions that the system every now and then doesn't upload the discovery. And then, you know, there's again nothing in the paper that says they were having issues. I will note though, on the first page of the investigator's report, it says police officers' body camera are not available, but I did receive a body camera footage from the arresting officer. So I don't know how reliable this is.
Well, while I have the relation number, I will sign.
Thank you, Judge. With that, one second. I will just-
Crossing out, personal.
No, I'm sorry, go ahead. That's okay.
I'm sorry.
Your Honor, having spoken with my client and explained his right to a preliminary examination, he does understand them. At this time, Judge, he will be waiving his exam. And then we'll just ask for the court to sign the order, and then we can determine if there are any motions in regards to this, then they can be handled.
I don't know what a third circuit judge is gonna do with the order. But it makes the torture.
Well, I guess the order would be to preserve
Whatever.
the evidence.
Okay, that's
And
fine.
so the prosecutor is now on notice, so is the OIC, that they are to look for this evidence and to preserve it. If the court does not feel comfortable doing an order, I can ask for it in circuit court.
I'm comfortable.
Okay.
So because I won't have it written out where I find your client over for the record, I am going to sign that order and I am granting your request.
Thank you very much.
Okay. Now with that, Mr. Lord, I'm going to ask you a couple questions, okay? Actually, one. If you don't understand, let me know. If you can't hear, let me know. And Mr. Kirker, do you have an objection to the waiver?
No objection, Your Honor.
Okay. So Mr. Lord, is it your wish to waive your exam today?
Yes,
You understand you have a right to a preliminary exam?
yes,
That if you were to hold and demand your exam today, that means the people, the prosecutor will have to show at the probable cause standard, which is a much lower standard, but still a standard, that the crimes that I read off, the charges I read off were committed in the city of Detroit and that you likely committed those crimes. You understand that?
yes,
And then I waive your exam, it means that you will not have that today, people will not have to prove anything today.
yes,
Okay. And knowing all that information, you still wish to waive your preliminary exam?
yes,
You're not waiving up your, or you're not, excuse me, you're not giving up your right to trial. You understand that?
yes,
Okay. Did anyone force you or threaten you to waive your exam today?
no, ma'am,
Okay. Did anyone promise you anything for you to waive your exam?
no, ma'am,
Okay. I find your waiver to be freely, understandingly, and voluntarily given. So I will have you bound over to Third Circuit Court for the regular information for March 23rd at 9:00 a.m. And I will have that order signed for you all, or maybe it'll be scanned over. I have to see if it's scale form.
An email after you sign it is fine, Your Honor.
Okay. Anything else on the record?
No, thank you very much.
I have one here for you all to sign.
Oh,
you're
fine.
Laura, yeah, go ahead. Sign the form.
May I approach?
Yes.
Oh, got it. Yes, sir.
Attorney Perlman, good morning.
Good morning.
How are you?
I'm here for Kwame Thomas.
Yes, so the clerk received information from Ms. McComb, right?
Yes.
From Macomb County Jail. Actually, I'll just let her tell you. She spoke to the director.
From Macomb County Jail that the date set by Your Honor was not a good date for him to be arraigned. Usually this goes through a different channel and it's kind of set up before it makes it up to the judge. So I don't know if we probably need to set it out another date, and I need to contact Macomb Jail to see what is a good date in order for Mr. Thomas Kwame to
Okay.
because normally you don't arraign at this point, when it comes up, it's for PCCs for Judge Sabree. This is usually done in front of a magistrate.
Right, right. So would it be possible to do the arraignment today with his appearance?
Now, that would be up to Judge Sabree. I'll pass her the file, Your Honor.
Have you spoken to your client recently?
Yes, I have. I have very recently, and so he retained me to cover this and another matter of his that he needs cleared up.
Okay. So I will waive his presence for the arraignment. Of course, I mean, if he comes on and says he objects to the fact that he's never been arraigned, then we'll have to go through the process again.
Okay. Thank you, Judge.
You're welcome. This is case 2155724, the people of the state of Michigan versus Darius Thomas Kwame. Mr. Thomas Kwame is charged with the following. Count 1, police officer assaulting, resisting, and obstructing, which is a felony with 2 years and or $2,000 as a penalty. Count 2, assault or assault and battery, which is a misdemeanor. This is the habitual offender third offense. Notice today is the day set for an arraignment. Appearances.
Alexander Fricker on behalf of the people, P86282.
Good morning, Judge Jeff Perlman on behalf of Kwame Thomas, P80517.
Okay, and Attorney Cromer, you're requesting, based off of the information you received from the court, to waive your client's presence. As he is in Macomb County, Macomb County has stated that today is not a good day for him to be arraigned. We scheduled this day at 9 o'clock, but Macomb County Jail is stating that it's not a good day to bring him onto. Is that your understanding and request?
That is my understanding, Judge, and I'm asking to waive his appearance.
Okay, I have no objection to that, as you have been in contact with him. And I'm also acknowledging that if your client, for some reason, states that he wants to have an arraignment in person or on Zoom, then he has that right, and we'll have to go through this process again.
Thank you, Judge. And as to the arraignment, my client would enter a not guilty plea, stand mute, and waive formal reading of the information.
Okay, and not guilty. Plea will be entered. And we need to set a PCC.
Sounds good. Thank you.
Okay, let's see. So how much time do you need? It'll be on Zoom, so what, 1 week? 1 week. Okay, I'll send it right out today. Hopefully that'll be a good day for Macomb County Jail.
Which day?
March 23rd,
Okay,
March 24th, Thursday or Friday next week.
Friday. Okay, that'll work.
Friday?
Yes, March 24th, you said?
Yes.
Yes, that'll work. Friday.
Wait, that's 2 weeks out. I'm
That is
sorry.
2 weeks.
I'm too far.
That date'll work. That date'll work for me as opposed to the 17th.
Okay, let's keep it at 24th, and can you do 9 o'clock?
Yes.
Okay, 9 o'clock it is. All right, anything else?
Nothing else, Judge. Thank you. Have a great day.
You as well.
Bye-bye.
This is the people of the state of Michigan versus Ibrahim Blair. Mr. Blair is charged with the following. Count 1, weapons, firearm, possession by a felon. Count 2, weapons, felony, firearm. Count 3, weapons, ammunition, possession by a felon. Count 4, weapons, felony, firearm. Count 5, weapons, carrying concealed with an individual under 30 minutes notice. And this is case 2355637, set for a preliminary examination appearances.
Alexander Kirker on behalf of the people, P86282.
Good morning, Your Honor. May it please the court, Carolina Sprinkle, P49898, on behalf of Mr. Blair.
Mrs. Blair, can you state your full name for the record, please?
Ibrahim Abdullah Blair.
Thank you. Okay, are all parties ready to proceed?
Yes, Your Honor.
We are, Your Honor.
Okay. Any preliminary matters?
Mutual secrets.
And Your Honor, at this time, the people have moved to admit pursuant to MCL 76611B1B, certified copy of the defendant's previous felony charge of carjacking.
I have not seen it.
Back through here with no attorney.
Thank you.
Your Honor, so stipulated for purposes of exam.
Okay, and for the mutual sequestration order, there is no one else in the courtroom other than the necessary parties. Is there an officer in charge that you're requesting to come in the courtroom?
Not at this time, but if the officer in charge does come in, I would ask for an exception.
With the officer in charge? Yeah, witness or testifying say?
No.
For anyone who is on YouTube or listening, who may be a witness on this case, now is your time to log off. You are not to be watching at this time. Any other preliminary matter?
No, Your
Okay, Mr. Kirk, call you first witness.
Your Honor, at this time, the people call Officer Linda Air.
Aliyah. That's AYA.
Okay, I'll swear you in. Swear to tell the truth.
Yes.
The door opens right to front. Thank you. Make sure you speak up. Yes, ma'am. Whenever you're ready, Mr. Kirk.
Good morning. Could you please restate your name for the record?
Yes, it is Lydia, Lidya, last name AR, spelled AYAR.
Are you currently employed?
Yes, I am.
Where are you currently employed?
With the city of Detroit as a police officer.
And how long have you been employed as a police officer?
Just over 5 years.
Were you employed as a police officer on February 8th, 2022? Sorry, February 8th, 2023.
Yes, I was.
And did you in fact work on that date?
I believe you might have the, is the date the 8th or the 18th? For the,
According to the investigator's report, it's the 8th.
okay. Yes, I was.
Were you by yourself or with a partner?
I was with a partner.
And what is your partner's name?
Police officer Mitchell.
Were you on foot patrol or in a scout car?
I was in a scout car.
And did your duties as a police officer take you to an area at or near 4577 Beaconsfield Street?
Yes, it did.
That in the city of Detroit, county of Wayne?
Yes, it is.
And what brought you to that area?
A traffic stop.
And what happened that led up to this traffic stop?
I observed a vehicle failed to use a turn signal when it made a turn onto Beaconsfield Street.
Did you attempt to make a traffic stop at this point?
Yes,
And did you make a traffic stop?
yes, at that location that you mentioned.
And did you make contact? How many passengers were in the vehicle?
There were 2 passengers.
Did you make contact with those passengers in the vehicle?
Yes, I did.
And which passenger did you make contact with?
I made contact with both. It was the driver and then a front passenger.
And are any of those passengers present in the courtroom today?
Yes,
Could you please point them out and identify an article of clothing that they're wearing?
yes, I see a gentleman standing behind, or I'm sorry, seated behind you. He's wearing a green shirt and he's got a blue shirt. Yeah.
Your Honor, let the record reflect the identification of the defendant.
So, what is there? You have the objection, attorney?
I object. He's sitting there with the mask with his head down. She literally couldn't see his face at the time that she gave the identification. I would ask them to correct that.
Mr. Blair. Mr. Carter, can you re-ask the question? To my understanding, Mr. Blair, I'm sorry, the gentleman in the first one had to get down.
Could you please point out the individual you came into contact with and identify an article of clothing that they're wearing?
Yes, it's the same gentleman that I had mentioned. His head is still down, however, just a few minutes before him and I were looking at each other in the face, and I recognized him to be Ibrahim Blair, who was a front passenger in that vehicle.
Your Honor, may the record reflect the identification of the defendant. And what happened when you made contact with the defendant?
I had initially asked him if he was a CPL holder or if he was carrying any firearms or if there were any firearms in the vehicle.
And what did the defendant reply to this question?
He was refusing to make eye contact. His head was low, and he very slightly shook his head. And at the time, I could see that his hands were slightly trembling, which indicated to me that he may have been nervous about something.
Okay, Mr. Blair,
I'm sorry.
I can hear you.
And in your experience, were any of these observations significant?
It just raises your alerts, because most times when people are nervous, it's because of something. It's not necessarily always something bad, but it just raises your alert that there could be something either in that vehicle or something circumstantial with that person, maybe their history, that just wants you to just be a little bit more on alert.
And what happens next during this traffic stop?
I heard that the driver of the vehicle, I could hear and I could see that she was unable to provide a valid driver's license.
You were able to see that she was unable to provide
Correct,
a valid driver's license?
correct. She didn't have any driver's license on her person.
And what happens after a driver is unable to provide their driver's license with the vehicle?
In most cases, it's circumstantial, of course, every case is different, but in this case, she was asked to step out of the vehicle because the vehicle is now subject to be impounded.
And is impounding the vehicle standard procedure?
If there's no valid, or no person present with a valid driver's license, then yes.
And did anybody provide a valid driver's license?
No, sir.
And what happened after both occupants were asked to step out of the vehicle?
I then began my inventory search of the vehicle, as the vehicle was subject to impound and inventory search is to be conducted.
And is the inventory search pursuant to standard procedure?
Yes.
When a vehicle is to be impounded?
Yes,
And did anything happen during the course of this inventory search?
yes, I recovered a firearm.
And where did you recover this firearm?
It was inside of a black grocery bag that was underneath Mr. Blair's seat.
And which seat was that?
The front passenger seat.
And the defendant was seated in the front passenger seat?
That's correct.
So was this firearm within the reach of this defendant?
Yes.
And can you describe the firearm that was recovered?
It was a black 9mm handgun.
And what did you do after recovering this firearm?
I made the weapon safe, which includes ejecting the magazine that was loaded with several 9mm rounds, locking the slide to the rear, which then ejected one more live round from the chamber. And then it was secured until based on evidence that they left.
Just to clarify, these were live rounds?
Yes,
And did you notice the defendant if he was a CPL holder?
yes, I did.
Did the defendant provide a valid CPL?
No, and it was confirmed via lien and our in-car computer that he also did not possess CPL, neither did the driver of the vehicle.
And were the items placed into evidence?
Yes.
Do you recall the evidence tag number?
No, I do not. May I refresh my recollection?
Would reviewing your report refresh your recollection?
Yes. Do you have them?
Yes. Do you recall the evidence tag number?
Yes, I do.
And what was that number?
691502-1.
And no further questions.
Morning, officer.
Good morning, ma'am.
I'm sorry, I missed your testimony as to how long you've been a police officer.
That's okay. 5 years.
5 years. And what is your primary responsibility?
Patrol function is my primary.
So as an officer who's routinely or regularly on patrol, you would be familiar with police procedure regarding vehicle searches, is that correct?
Yes, ma'am.
And so your testimony is that this vehicle was pulled over for a routine traffic stop?
For failed to signal, yes.
Failure to signal. Did you observe anything else at the time?
In regards to what, like it's not the
Traffic violation, any other infraction?
No.
That's failure to stop,
Failure to signal?
failure to signal. Thank you. All right. And were you the officer that made contact with Mr. Valero, or was it your partner?
Initially, it was me.
And did you ask Mr. Valero if he possessed a valid driver's license?
No.
Testimony today was that the vehicle was only subject to inventory search if no one in the vehicle possessed a valid driver's license, correct?
And also because the registered owner of the vehicle was not present.
So the registered owner of the vehicle was not present.
Correct.
So neither the driver nor Mr. Blair were the registered owners of this vehicle.
Correct.
And did the vehicle, if you recall, have valid tags?
Yes, it is.
And did you acquire the vehicle was that validly insured?
It did have insurance also.
So this vehicle could lawfully be operated on the street, is that correct?
If by a licensed driver, yes.
Thank you. Now, according to current Detroit police procedure, when you conduct an inventory search, you're required to complete an inventory sheet or log, is that correct?
Tow card, yes.
And did you in fact complete that time?
I know it was completed, I can't. Yes, I did.
And have you submitted that to the prosecutor to be included with discovery?
Have I submitted the tow card?
If you submitted it, or do you know that?
I'm unsure. If it was
And your testimony is that the firearm that you described was found underneath the passenger seat?
Yes, ma'am, the front, yes.
Was it visible, or other words, in plain sight, or did you actually have to lower yourself and look under the seat to see the firearm?
No, it was not in plain sight.
Thank you, Your Honor. I have no further questions.
No further questions.
I have a question about. You said no, sir. Okay, thank you. Any other ways to-
No witnesses from the computer.
I believe the officer in charge stepped forward to the courtroom during part of testimony. Whenever you're ready. Unless, just have it.
No witnesses, Your Honor.
Okay.
At this time, the people would move to find over on all counts. Those would be count one, weapons, firearms, possession by a felon. Count two, weapons, felony, firearm. Count three, weapons, ammunition, possession by a felon. Count four, weapons, felony, firearm, and count five, weapons carrying concealed. So they heard from the witness, a traffic stop was conducted for failure to signal. Upon making contact with the passengers of the vehicle, the driver was unable to provide a driver's license, and the registered owner was not present. So pursuant to department policy, the vehicle was subject to impounds. Prior to being impounded, the vehicle was also again pursuant to department policy, subject to an inventory search. The witness conducted the inventory search herself, at which point she recovered a firearm under the front passenger seat, where she saw the defendant sitting when she made contact with the passengers of the vehicle. As she described, it was within the reach of the front passenger, with the defendant. When she was making the firearm safe, she recovered numerous live rounds, both in the magazine and one in the chamber. At this point, the defendant was asked if he had a valid CPL, which he said he did not. This was confirmed through Liam, as well that the defendant did not have a valid CPL. People believe that they met the burden of proof for probable cause and would ask to find over.
I'm going to ask the court to deny mine over for two reasons. Specifically, I would challenge the search of the vehicle as not being lawful. The testimony is that there was never an inquiry as to whether or not Mr. Blair possessed a valid driver's license, which means the vehicle could have certainly been driven had that inquiry been made and Mr. Blair been able to drive the vehicle. The testimony is that it was lawful to be operated on the street. The second reason I'm asking the court to deny bind over is that the registered owner of the vehicle was not present. Testimony is that neither my client nor the driver was the registered owner of the vehicle. Therefore, there's no testimony that my client even knew the firearm was present. There's no testimony that he made any admissions regarding that firearm being there. This simply was found in a vehicle that he did not own, was not driving. I'd ask the court to deny bind over on terms.
No, Your Honor.
Okay. Okay, I am not going to run or recite the facts. The two issues defense counsel has brought up are in regards to the search as well as her client not having knowledge of the firearm. I'll start with the firearm. Based off of traffic stops, based on testimony that it was for a failure signal, which then triggered Officer IR to initiate a traffic stop. Initiate a traffic stop interaction with the defendant. She stated that he was nervous and was looking down and asked if he had any guns in the car. And based off of the driver not providing a driver's license, they were asked to step out of the vehicle. The police have a lot of discretion, not always a good thing, but based off of vehicle traffic code, if the driver of the vehicle is operating the vehicle without a license, it can be impounded still. The officer could have had the defendant if he had a license, and he could have led, or she could have led the defendant if he didn't drive. But based off of traffic statute, the car can be impounded based off of observing the driver not having a valid license. Second, with the search, that comes out of being able to impound the vehicle based off of violation of traffic law. With the driver not having a driver's license and stop, which was legitimate for failure to signal. I believe both of these will be a question of fact issues that Attorney Sprinkle brought up for the trier fact as to whether or not the search was legal and whether or not having the registered owner not present means that the defendant may not have known about the gun. This will be bound over based off constructive possession and heard that Mr. Blair knew that the gun was under the car and didn't reach. So I will have him bound over for the regular information March 16th at 9:00 a.m.
That's the drug.
Marshall Jones?
Oh, I got that all down. It'll be downstairs.
Morning, how are you?
Attorney White. Attorney White.
Good morning.
What do you have today?
Brianna Jones. And Judge, just so you're aware, she called me about transportation. I told her at least log in.
Okay.
And just so you're aware, Judge, I still don't have discovery, so I'm gonna make my motion, but we'll see what's going on with all that.
Okay.
So hopefully it'll be quick.
Hopefully I get something quick today. First. I'm sorry, what's your name?
Mike's Cody, C-O-D-Y.
Thank you.
Bradford.
Attorney Show, you ready on Mr. Gillum?
Yes, Your Honor.
Well, as ready as you can be, I should say.
Come again?
I said as ready as you can be.
Yeah.
Okay. This is 2355052, the people of the state of Michigan versus Aaron Gillum. Mr. Gillum is charged with count 1, breaking and entering a building with intent, and count 2, larceny in a building. Today's the date set for a probable cause conference. Appearances.
Good morning, Your Honor. Daniela Parrish on behalf of the people, P85495.
Good morning, Your Honor. Alexandra Cho with the Neighborhood Defender Service of Detroit, P85948, appearing on behalf of Mr. Gillum.
Okay, and I don't see Mr. Gillum present. Attorney Cho, have you had any success with contacting your client?
Your Honor, I have not been able to contact my client. The number that we have is not able to go through. So I've not been able to even leave him a message. My investigator has been attempting to locate a number and phone number for him. So I'm unaware if he's, aware of this case as well, but we have attempted to get in contact with him.
Your Honor, and I may be wrong about this and reviewing it appears, please correct me if I'm wrong, that this is the second PCC on this case. Therefore, based on the information defense is up, them not having contact, people would ask for a case.
Okay, I'm checking to see the second.
I did do the February 23rd, Your Honor, but I'm not sure if that.
I do see February 23rd at PCC was held. Yes, and adjourned to today. The defendant did not appear. Okay. And Attorney Show, you did what you could. So I am going to issue a case. It'll be a personal $1,000.
And if I do get in contact with him, Your Honor, I will begin the process again with the court.
All right. Anything else?
That is it, Your Honor.
All right, have a good day.
Thank you. You as well.
To the Attorney McRipley, good morning.
Good morning, Your Honor.
I already know your issue. It's just a matter of whether or not the people are willing to dismiss your client's case via Zoom or with, I don't know, if has a birth or death certificate been provided? I'm not sure what the
Which case is this, Your
the court defendant is Laura's.
Honor? The defendant that passed away. Were we able to, not that I don't believe it, just so that we can put it in our record of PDK, do we have a death certificate on that defendant?
I didn't receive one.
Not if it just happened yesterday.
It just happened yesterday.
That's what I've been informed of.
Oh, I think it happened before because
No, it happened a while ago.
Yeah,
I received an
because-
email weeks ago.
right.
Oh, okay. Well, I just found out today.
Yeah, the funeral was 2 weeks ago.
Okay.
But yeah, she should have a death certificate. Anyone can't the prosecutor just confirm with the ME?
Well, I hope.
Get the ME's number?
Well, she's not here. It's Ms. Narcessian, so, I asked if she would dismiss the case via email because she wanted to have the death certificate before dismissing.
Well, usually the ME's number is usually good enough.
Okay, well, I can't do anything about it because she's not here and she wants the death.
But do I have to pay the park, Your Honor?
You can stay on Zoom.
Or if I may suggest to defense counsel, if he could email Mr. Narcessian himself, maybe he, whether it's, to follow up to ask for a dismissal, but I am of the same information as the judge that we usually require something so that we can put in the file.
Can you give her a call? You have Ms. Narcessian's phone number to call her. You all can talk.
Oh, yeah. Oh, yeah.
You have her email address?
I don't think so. Let me look up my.
Find what was the defendant's last name?
Wait, Wilson.
Thank you.
Was your client on and then logged out?
She said it kicked her off. She texted me. I told her to log back in.
To the person with iPhone and the camera off, can you please turn your phone on, your video on, and say your name? Now, what's your name?
I'm sorry, is it on mine?
What's your name?
It's Brianna Jones. Give me one second.
Okay, calling case 2259416, the people of the state of Michigan versus Brianna Jones. Ms. Jones is charged with count 1, malicious destruction of personal property, $1,000 or more, but less than $20,000. Count 2, assault with a dangerous weapon, felonious assault, the commission of a felony with a motor vehicle advisory, set for a preliminary examination today at 10:30. Appearances.
I was just confirming, this is not my case, it's her first case, so I'm just, there appears to be an issue If I could just have a moment to check with APA Kirker to confirm some information. I believe defense may have a motion as well. Can I just have a moment?
Sure. Attorney McRipley, I just sent you, APA Nersessian's email address in the chat.
All right.
Yes. Danielle Parrish on behalf of the people, P85495.
And Dennis Whitey, P79560, on behalf of Ms. Jones, who's present by way of Zoom, Your Honor. My client, just so the court's aware, my client reached out to me this morning with transportation issues. Asked if she could Zoom in. I advised her it was in person. However, I would ask the court's permission when I got here. But she has promptly appeared and has been in contact with me all morning.
And no questions from the people.
Okay.
Your Honor, unfortunately, the people are not prepared to proceed at this time. Not only do we have insufficient information on the case, but we have no necessary witnesses here. So at this time, for the interest of justice, we can't proceed at this time. Okay. And we have no discovery to provide to defense.
And given that, Judge, we would, if they're not ready to proceed, today was the day and time set for the preliminary exam. We are here. Unfortunately, I honestly have to admit I'm not ready because I still don't have a police report in this case from weeks ago. No fault of the prosecutor's office. They've been trying. I've been in good communication with them. But given the totality of circumstances, we requested dismissal. And I explained to my client that would be without prejudice and what that means. If the court were to grant it.
I will dismiss without prejudice for no complaining witness, be ready to go today and no discovery. What was the third issue?
That was it.
That was it?
Yeah, I just stated I've been in good contact with the prosecutor in this case.
Okay.
And they tried.
Dismissal right now.
Okay. Thank you, Judge.
Anything else on the record?
Nothing for the people. Thank you, Your Honor.
Nothing for me.
Okay, Ms. Jones, your case has just been dismissed without prejudice, so you can
Okay.
log off.
Okay, thank you.
You're welcome. Have a good day.
You too.
Judge, that's probably the shortest issue you've ever had.
Yes, it is. That's why I was like, let me clear everybody out because here comes Attorney Whitey. When I mentioned, so there's a case this morning, no dash cam.
Oh.
So we're off the record, but. Attorney Whitey, won't take long for the dismissal.
Oh, okay.
Attorney McRipley,
Yes, Sean.
I just spoke to AKA your deputy, and she said that you are okay with staying on Zoom, you don't have to come in, she has information that the client has passed.
Wanted to ask for something.
All right. Thanks.
You're welcome. Michael Jones?
Your Honor, prior to, I apologize, as I would like to jump in to do an adjournment on Evans prior to us. Is that okay?
Yeah, that would be. Oh, back.
Baxter checked in. I'm not sure about the attorney yet. I went to a part.
Take care of Jonathan Evans. Okay, this is case 2355421, people of the state of Michigan versus Jonathan Raphael Darius Evans. Mr. Evans is charged with count one, and only count one, controlled substance delivery, manufacture of cocaine, heroin, or another narcotic, 450 to 999 grams, with a habitual offender second, and notice set for exam. Appearances.
Alexander Kirker on behalf of the people, P86282.
Good morning, Your Honor. Nancy Kessler from Neighborhood Defender Service of Beacon, appearing on behalf of Mr. Evans, number 80549. Your Honor, for today's court purposes, I would ask the court to waive Mr. Evans' presence since we did have off the record discussion regarding the nature of this case.
I will waive his presence. And I believe Mr. Kirker, you requested prior to today adjournment for this case.
Yes, Your Honor. One of the necessary witnesses is on furlough through the end of this week.
last, you had knowledge of that, and I asked it via email for all parties, if you had an objection to it, also request.
Correct, Judge. Mr. Turner did provide an email about a week ago, and then again reached out to the court and myself in regards to his witness not being available, given that we were provided with sufficient time, and given that the officer is on furlough, I indicated that if the court finds that to be a good cause, I would not have an objection to it. To the next week.
Okay, I will find the cause, saying that it was not the day of, it's a surprise, therefore, and he's on furlough. So, but we discuss a date.
We didn't discuss the date, but I know he's back as of next week.
Attorney Jackson, are you here at all next week?
I am not, Judge, but I can make myself available. I can come on the 14th. As well as the 13th in the morning. Well, late morning. I'm also available on the 17th, Judge, later in the morning.
I can do the 14th. (8:30 or 9 o'clock?
9 o'clock, please. And Your Honor, if I may, do you have anything later on in the morning? I do have one other matter on the 14th, but I can do 9:30, just so that the court does not wait for me.
We have the 10, 10:30, 11, and 11:30.
Those are openings?
No, those are scheduled already.
Yes, all right. Is the 9:30 taken or?
No, it's a 9:30 here for.
Judge, I'll make it work.
Yeah,
I'll
we're here,
figure it.
so whenever I know you'll show up or you let us know. Somewhere we'll fit you in.
I'm okay with scheduling it for 9. I'll try to make it work with my other.
Okay.
Thank you.
And I will be flexible with. Be careful, schedule it for 9.
Thank you.
Okay, we're off the record on Evans. Ready to go on Jones? Case 2355203, people of the state of Michigan versus Michael Jones. Mr. Jones is charged with 1 pound of weapons carried concealed, but able to that for further examination.
Good morning, Your Honor. Danielle Serge on behalf of people T85495. Good morning, Judge, you and your staff. Good morning, EPA Parrish. Cody Bradford with NDS Detroit, P85944. On behalf of Mr. Michael Jones, who is present in the courtroom. Mr. Jones, can you state your name for the record?
Michael Jones. My name is Michael Jones.
I didn't hear the last part.
My name is Michael Jones.
Good morning. Okay, are both parties ready to proceed?
Yes, Your Honor. Yes.
Okay, any preliminary matters?
I would just ask to sequester any of the testifying witnesses who may be here or on YouTube or Zoom.
Okay, so for the record, in the courtroom, there's no one present other than staff and attorneys and Mr. Jones. For anyone who is watching on YouTube Live or on Zoom, if you are a potential witness, it's now time for you to log off. With that, any other preliminary matters?
Nothing from the people. Nothing from the defense.
All right, call your first witness, Ms. Parrish.
Thank you, Your Honor. The people called Deshaun Perry.
Spirit.
I do.
Everybody, Mr.
Thank you. Thank you. I was just about to ask you to do that. I'm a little hard of hearing, so appreciate you speaking into the mic when answering the questions. I'll ask you a series of questions, and then afterwards defense will. If there is anything I ask you, please stop me. If you don't understand, please stop me and I'll rephrase, okay? Please restate your name for the record, sir.
Sean Perry,
Mr. Perry, who are you currently employed by?
Detroit Police Department,
In what capacity?
police officer,
How long have you been a police officer, sir?
a little over 3 years.
Were you employed in this capacity on January 15th, 2023, sir?
Yes,
Were you working by yourself or with a partner on that day?
with a partner,
Which, sorry, what is your partner's name?
Officer Flannel,
Say that last name again?
Officer Flannel,
Oh, there. Thank you. Were you in a scout car on that day, sir?
yes,
Was it fully or semi-marked?
that's gonna be a semi-marked.
Could you please tell the court what that entails?
It's a black scout car instead of white with Detroit Police on both sides.
Were you in a full or modified uniform on that day?
Modified,
Okay, and what does that entail, sir?
green pants with a black vest that said Detroit Police on the front and the back.
And were you wearing a functioning body-worn camera on that day?
Yes, I was.
Did your duties as a police officer take you at or near 17771? Let me repeat that, just in case there's any numbers in there. 17771 Fargo Street, the city of Detroit, County of Wayne.
Yes,
Why were you near or at this location?
on routine patrol.
While on patrol, were you driving or a passenger in your scout car?
I was a passenger.
While at or near this location, did you observe something, sir, that drew your attention?
Yes,
What was that?
a Jeep, sitting next to a vacant lot.
Was the Jeep parked or running?
It was parked and running.
As a result of your observation, what if anything did you do?
I advised my partner my observation and we pulled next to the vehicle. Once next to the vehicle, I observed that it was occupied 2 times by a male driver and a male passenger.
May I ask why you wanted to pull up to the vehicle? To get further investigation?
Yeah, it was like 9 o'clock at night or 8:40. And the vehicle was on and running next to a vacant lot. It was the only car that was on. The biggest thing was I wanted to see what was going on with the car because 2 rows apart.
Say what the last part you said?
I just wanted to see what was going on with the car because it was on, it was parked next to a vacant lot.
Okay. What did you do after you recognized that there was occupants in the running vehicle?
I spoke to him, see what's going on, see if it's okay.
And when you say you spoke to them, can you describe to us where your vehicle was at, where you were at, and where the people were that you were speaking to?
Yes, we drove past the vehicle, we ended up next to it once I observed that it was occupied.
Did you remain in your vehicle at this time when you made initial contact?
Yes,
How did you make initial contact, sir?
I spoke to the driver, at this time, I was in the passenger seat, next to the driver's seat. And I began speaking to him.
Okay. What information did you obtain when you began speaking to the driver?
I asked, was he okay? He said he was fine. He said he just pulled over so that, the front seat passenger could use the restroom so he could urinate outside.
Okay, so based on that information, how did you reply to the driver?
I told him that he can't urinate in public. And, I'll advise him that.
Okay. After you advised him that he cannot urinate in public, did you obtain any other information from the driver?
Yes, at that time I asked him if he had the license.
How did he respond?
He said, no, he did not have the license.
After the driver admitted to not having a valid
driver's license. What did you do, officer?
After I asked him about his license, he told me he did not have a license. I guess he began to move around the vehicle. I don't know if he was attempting to locate his license. I don't know. Due to him moving around like that though, I asked him, was he a CPL holder? And he said that he was.
Okay. So, the fact that he does not have a valid driver's license and indicates that he's a CPL holder, what do you do with this information, officer?
At that time, I eyed the scout car and I approached the driver side of the vehicle. Speak to the driver some more. At that time, I went to the vehicle to give him that he was not a CPL holder, and that he was open carrying his firearm.
And what?
He was open carrying his firearm.
At this time, could you tell me, once you have exited your vehicle, approached the driver, after he's indicated that, has now, can you tell us from your observations, has your partner, done anything different? Like, have you initiated a traffic stop, or your lights on, or are you just continuing with your investigation at this time?
Well, I passenger side of the vehicle, approached the driver's side of his vehicle. My partner repositioned our scout car behind their vehicle, and I observed my partner approach that vehicle on his passenger side.
So now, you're outside of your vehicle, engaging with the driver, and your partner is on the opposite side, with by the passenger, is that correct?
Correct.
So after the driver, before we get into details after he indicated he was open carry, would you be able to recognize this driver that you engaged with that day?
I would.
Okay. Is that driver in the courtroom today?
He is.
Could you please tell the court where that driver is in the courtroom and an article of clothing that they're wearing?
He's wearing a black shirt. It's on defense counsel.
Your Honor, may the record reflect the identification of defendant Michael Jones, please? Thank you. Officer, so, what's your approach to the defendant? So you're saying I know you said he's open carry, so he then told you that, could you explain, he told you that he was not a CPL holder?
Yes, so when I engaged him, I asked for a CPL, so as a part, at that time, he advised that he was open carrying.
After the defendant indicated that he was open carry, did he indicate where this weapon was that he was open carry?
Yes, he pointed to his right side, right near his right leg.
Okay, when you say his right side, when you say he pointed to his right side, was he pointing to the right side of where he was at, or the right side of his person?
The right side of his person.
Okay. Could you describe to the court, basically where that is in the vehicle?
Like I said, it was right next to his right leg. His right leg was kind of covering it, so I couldn't see it until he got out of the vehicle.
So you said he got out of the vehicle, so let me back up. After he indicated where his weapon was, what did you have the defendant do?
Well, I can't believe I detained him from the vehicle due to him not having a license and due to him lying where the firearm was at without a CPL. Typically, that's not how you're supposed to carry your weapon.
So you said you detained him. Did he remain outside, or did you take it back to your scout car?
I believe I secured him with the scout car.
After you secured the defendant in the scout car, did you recover the weapon?
I did.
Did you do it yourself, or did your partner do it?
I did it.
Do you recall what type of weapon it was, sir?
Yes, it was a black and silver cannon.
What is it? What's it called?
Black and silver cannon. CANIK. TP9 Elite.
Those of us that are not super familiar, is that a semi-automatic or a revolver? Which type of weapon is that?
It's a semi-automatic.
Once you recovered that weapon, officer, can you tell us, was the weapon loaded?
Yes, I already recovered it. I took it back to the scout car, made it safe where I discovered it was loaded.
After you detained the defendant and made the weapon safe, sir, could you tell us, did you do an investigation to confirm the CPL status of the defendant?
Yes, I verified, what was going on with his license, his driver's license. He had a revoked driver's license. I ran him for a CPL. He did not have a CPL.
Adam, I'm going to object to hearsay to anything that comes from lien, Your Honor. The only way that can get in is if it's a certified business record, and we have no certification or foundation of any of the stuff that would have come off of lien, other than what the officer says he saw. That's an out-of-court statement asserted for the truth of the matter. And again, the only way it can come in is the business record, and we have no certified business record that I've presented. So it has to be stricken from the record.
Your Honor, that is incorrect. It is not hearsay because it is not a statement. Lien can't make a statement. The course of this investigation is electronic, as you both know. It is not a statement made for the truth of the matter asserted. It is a business record that is used to verify, but again, it is not a statement. It is.
Officer Craig, did you observe the lien results yourself?
Yes, I ran it and leave myself.
Your Honor, again, just briefly, the person who put the information into lien could itself be hearsay as a statement. And because of that, the only way to get that in is through a certified business record, which we do not have.
Again, that is not the only way. We have been doing lien, as defense knows. Officers use the lien in their scout car. The information provided is not hearsay. It is under the business record exception. But that business record does not have to be brought here because, as defense knows, we cannot actually show the defendant's lien or provide it to anyone who is selling distinguishing. So, but it is used in order to verify the information. And the officer just indicated that's what he did, and it is the correct way to do it.
These that Officer Perry observed, these searches don't allow. I'm sorry, you can't hear me?
No, I'm sorry.
Seeing that Officer Perry did the lien search himself, I'm going to allow it. You have got the information from his partner or was advised. I would rule it as hearsay.
Thank you, Your Honor. During this investigation, Officer Perry, did you yourself find out whether or not the gun was registered?
I did. I don't exactly recall if it was registered to the owner, to the driver or not.
Okay, if I were to show you your.
1 second, Ms. Perry.
I'm sorry, yes, I did. I'm not sure if the firearm was registered to the driver or not.
If I were to show you your police report, I'm just checking here to see if that's actually here. Would that refresh your memory?
If it's in my report.
Your Honor, may I approach? Yeah. Thank you. Officer, please review your report. Once you're done reviewing your report, if that information is in your report, if you have that information and your memory has been refreshed, please let us know and I'll take the report back and continue with questioning.
No, ma'am.
So the report's refreshed your memory, sir?
Yes.
And did you just indicate that whether or not the weapon was registered is not your report?
Yes.
Thank you. After recovery of the weapon and your investigation into the defendant's license and CPL, what did you do, sir?
At that time, I lost my part of my discovery, and the driver was placed under arrest.
Was the weapon and its ammunition placed into evidence, sir?
It was.
Your Honor, if the court would not mind, I'd like to read the
the evidence tag, which is on the police report.
No objection from defendant.
Your Honor, evidence tag on defendant, excuse me, Officer Perry's police report indicates evidence tag number 689701-1 for firearm and 689701-2 for the loaded magazine. No further questions at this time. Thank you.
Rob?
Good morning. Is it Officer Perry?
Yes.
Okay, nice to meet you. Similar to what APA Parrish said, if I say something that's confusing, you don't know, let me know, I'll stop and try to rephrase it.
Okay.
So you had stated that you were on routine patrol, correct?
Correct.
So you weren't, you didn't have a call from anybody that you were scoping the suspect for in the area?
I was not.
No. And you did not see any crimes that occurred around that area, correct?
Not at that time.
And when you first approached the vehicle, you did not see any weapons initially?
No.
And at one point you had stated, you said it was the only car on.
Run.
What do you mean by that?
Running.
Oh, right.
Yes.
Okay. But there were other vehicles on the street.
Parked in front of homes, yes.
I'm sorry,
Parked in front of homes,
but there were multiple vehicles parked on that street.
not near that vehicle, further down the road, yes.
Okay, but it's a residential street.
Yes.
And when you say they were parked in an open field, what do you mean by open field? Is that a lot that just doesn't have a house on it?
Yes.
And you said you were the passenger of the vehicle?
Yes.
When you pulled up next to the vehicle, you actually, or your partner, you and the vehicle, are stopped in the middle of the street.
Next to the running vehicle, yes.
So their vehicle is next to the curb, correct?
Close to the curb, yes.
And then your vehicle is to the
The left.
on the driver's side, but you're parked in the middle of the street.
Yes.
And so you said that you stopped to make sure that they were okay.
Yes.
And at one point during the conversation, you said that they had indicated they had stopped to go to the bathroom.
The driver stated that he pulled over so the front seat passenger could urinate outside, yes.
So he said that they were urinating outside?
The driver said, they both said yes. The front seat passengers had just got done urinating out in the lot.
Okay. So they said that they went urinating in the open field?
Yes.
Did you have body cam footage?
Of him saying that he urinated outside?
I'm just asking, did you have body cam footage?
Yes.
Okay. And it was activated?
Yes.
And it was functional?
Yes.
Okay. What would you say if the body cam footage shows that they just said, we went to the bathroom?
He indicated, I immediately advised that he could not urinate outside, and I believe they apologized for that.
Right, but if the body cam shows that they said nothing about where they went to the bathroom, would you admit that you might be mistaken on that?
I might be mistaken.
Mistaken as to where they went to the bathroom?
No. I advised that they couldn't use the restroom outside.
I understand that, that's not my question. Did they tell you that they were urinating outside?
I believe so.
Okay. If I played your body cam footage, would that help refresh your
It
recollection?
would.
Before I do that, let me ask, is it illegal to be parked on the street?
Is it illegal to be parked on the street? No, it is not.
Is it illegal to be parked on the street and still be in the vehicle?
No.
Correct. While we have silence, I want to really identify the gentleman.
Off the record. To the gentleman in Division 2, can you state your name, please? The Wayne County Jail? Yes, what's your name?
Justin Mallory.
Say it again.
Justin Mallory.
Justin Mallory. Okay, your attorney has not checked in yet, so as soon as he's here and we're done with this whole, we'll call your case, okay?
Okay, thank you.
You're welcome.
So I suppose we you just gotta hold up.
You need co-host?
I'm sorry.
You need co-host?
Yes, please, so I can share.
You don't have anything from Mallory? No report?
I'm gonna test it real quick, try to see if the sound went right.
You peed on yourself?
Can I proceed, Judge?
Yes.
So I've zoomed into your court, Judge, with what is defense's proposed exhibit 1. Stopped at 102, just to lay the foundation. Officer here, excuse me. Does this look like your body cam footage from that day?
Yes.
Okay, does it look fairly accurate to how it was that day?
Yes.
This is at 102. I'm going to rewind it to about 32 seconds.
Spot. I'm just making sure y'all straight. Y'all say y'all just got done.
Yes, sir.
Man, that's you peed on yourself?
I said me myself. It's nothing funny, sorry.
Where you pee at, man? You can't do that, man.
No, it's nothing funny, man. Nothing funny.
Y'all all right though?
Yes, sir. I promise.
You got a good license, sir?
Pausing at 50 seconds. Officer Perry, did anybody state that they had peed in a field?
I believe the front seat passenger stayed taking the outside.
The front seat passenger said he peed outside?
Yes.
Can you play that again? Because I don't think the audio is loud.
Sure. It'll probably lag a little bit, Judge. If this doesn't work,
Rewind it a little more, maybe that's why, maybe just like a couple seconds.
What'd you say? I'm
before.
sorry.
Could you rewind it maybe a couple, there's that lag?
Judge, if this doesn't work, I'll just log out and do it with my computer. So I've rewound it to 20 seconds, pressing play.
I'm just talking to you right now, man. Y'all just parked in the weird spot. I'm just making sure y'all straight.
Listen, I ain't even with that.
Y'all say y'all just got done peeing?
Yes, sir.
Man, that's you peed on yourself?
I said me myself. It's nothing funny, sorry.
Where you pee at, man? You can't do that, man.
No, it's nothing funny, man. Nothing funny.
Y'all all right though?
Pausing at 49 seconds. Were you able to hear, Judge, or should I play it without Zoom?
I could hear Officer Perry, but I could not hear what the passengers of the vehicle were saying. As far as it relates to whether or not they said whoever was beat, or there was any mention of it.
So we can take it off until.
Okay.
Maybe if you play it.
Sure.
Just play it, so now it's just a matter of replaying it, so that here.
May I approach, Judge?
Your Honor, may I join?
Yep.
Thank you.
And just for the record, the replay of the same, but hopefully better audio, so that I can hear.
Yes, this is still a defense proposed exhibit 1. I'm at 19 seconds. Full volume.
Y'all just parked in the weirdest spot. I'm just making sure y'all straight. Y'all think I just got done peeing? Better? You peed on yourself? Where did you pee at? You can't do that, man. Y'all all right now? You gotta go back to server.
Okay, all right. I heard.
Judge, I stopped at 50 seconds. So Officer Perry, you're saying that in that audio, they stated that they urinated in an open field?
The varsity pastor, yes.
Okay, Judge, move to admit this into evidence.
Any objection?
No objection, Your Honor.
Amendment as defense exhibit A.
You didn't see them use the bathroom, did you?
No.
And they had indicated that they were fine as well.
Yes.
When you arrested Mr. Jones, you did not give him his Miranda rights, did you?
No.
And at some point during the interaction, you actually take off your body cam footage, your body camera,
Yes.
multiple times actually.
Yes.
Is it against DPD policy to take off your body cam when you have interactions with civilians?
I didn't have interaction with him at that time.
I'm sorry?
I didn't have an interaction with him at that time. I called my PBU to get some clarification on some things.
So when you took your body cam footage, he was not already in the backseat of your car?
He was. The camera was still holding up.
But you still took it off?
Yes. The camera never stopped rolling.
I understand that. I'm talking about just your body cam.
Oh, yes, sir.
No attorney. Just a
Nothing further. Thank you, Officer Beard.
Yes.
There's no further witnesses, Your Honor.
Any from defense?
No witnesses on behalf of defense, Judge.
Okay, disparage argument.
Your Honor, people move that defendant Michael Jones be bound over on count 1, weapons carried concealed, and reserve argument.
Attorney Brett?
Judge, we object to binding over this case. What you have from this officer is that he sees a vehicle that is parked near the curb on a residential street that has other vehicles doing the exact same thing that Mr. Jones allegedly was doing, that started this wellness check to check on Mr. Jones in the passenger. After that, they start asking questions about what they're doing. And then when we indicated that they had stopped to go to the restroom, there was no further follow-up questions about where, he said, where'd you go to the bathroom? And nothing from the video that I've heard, I'm saying as an officer of the court, did Mr. Jones or the passenger say they were peeing or doing anything in an open field. just admitting that they were going to the bathroom that could have been in any number of those residential houses there is not a crime. Additionally, there has to be some reasonable suspicion to have detained Mr. Jones. And I know the officer will say, you know, they're not under arrest unless they're in handcuffs or we're detaining them and that's not an arrest. That's not it. It's a custodial interrogation where the person would not feel free to leave. You have Mr. Jones, who is parked next to the curb. This police car, which is marked and has 2 marked police officers in it, pull up immediately beside his vehicle. They're parked in the middle of the street. For Mr. Jones to have left, he would have had to pull up through other parking spots in front of residential houses and then gotten in front of this police car. So saying that they had not started some traffic stop just because they didn't put their lights on is not correct, Judge. Mr. Jones would have either had to hit their car or move up through parking spots to then get into the road. Now, for this wellness check, if there was a wellness check every single time the police came into contact with the civilian, then what is the purpose of the Fourth Amendment? Why do we have it? There is no reasonable suspicion here, and I would say, Judge, look to People v. Shabazz, which is a Michigan Supreme Court case. Let me get you the site. That is People v. Shabazz, S-H-A-B-A-Z. Citation is 424 Mich 42. This is from 1985, Judge. What the Supreme Court of Michigan said when we're looking at reasonable suspicion as a reason to stop somebody is were the police officers investigating a recent crime in the area? You heard the officer say no. There was no warrants and there was no crime that was reported that would have indicated that Mr. Jones and his passengers should have been stopped. The second part is, was the defendant unknown to the cops and was he a subject of an arrest warrant? No, he was not. Officer Perry said there's no arrest warrant. Did the defendant resemble an individual that is suspected of a crime? There was no suspected crime. Did he have contraband or weapons visibly on his person? You heard from the officer, he didn't know there was a weapon until Mr. Jones got out of the vehicle. He couldn't confirm, there was a weapon until he got out of the vehicle. The officers were marked. Mr. Jones did not feel like he could leave. And again, the officers did not see him or the passenger urinating in a public field. And they're saying, well, I asked him for his driver's license and he didn't have one, so that's enough for me, reasonable suspicion to pull him over. What was the reason for asking for his ID in the first place? There is none, absolutely none. There's no reasonable suspicion that a crime was committed because 2 individuals were parked on a residential street next to the curb where they are allowed to be parked. No other crime was going on in the area. There's no warrant for Mr. Jones, and there's no warrant for anybody who looks like Mr. Jones. There is no reasonable suspicion in this case, Judge, and we'd ask for it to be dismissed. Thank you.
Eric? Thank you. I respectfully disagree with your defense. As the testimony indicated, Officer Perry was doing a wellness check because there was a vehicle running parked in front of a vacant lot. As he indicated, there were not cars immediately close by, and more importantly, there was no other cars that had occupants in it running. So I believe the video nicely corroborated with the officer's testimony that he asked them. He was doing a wellness check, ask him that if everything's okay. Couldn't clearly hear everything that both occupants were saying, but based on the officer's response to each of the comments from the occupants, it also corroborates everything that the officer indicated, that he inquired to see if everything was okay. They indicated that whichever, I couldn't hear clearly if they said they were going to the bathroom, they peed, or they urinated, what exact words they used, but you could hear the officer clearly saying, where'd you do it? Inside the car? And then after they responded, he said, you can't do that. again, corroborating his testimony that he was telling them that you cannot, go to the bathroom, urinate in a public, place outside. So, I would say that, them being parked on the street with no other cars running, no other cars having occupants, no other cars having occupants indicating that they just urinated, is not the exact same thing as defense, was trying to state. As I said, the video corroborates nicely everything that the officer indicated. In a vehicle, even if you are parked, you're in a running vehicle on a street, nowhere did anyone say whether a defendant lives there, there's no house in front of them. It is normal for a police officer to ask for a license. You are the driver in a vehicle, even though it's parked, it's running. But let's say that wasn't even the case. At this point, now we have the occupants in the vehicle indicating that they urinated. And I believe all I heard was, don't worry about it. And then the officer got out and said, after he asked if he had a valid license, so he got out to inquire further. So at this point, he does have reasonable suspicion after they admitted that they urinated in public and therefore asked for the valid license. The driver was, based on the testimony, indicated, he admitted he doesn't have a valid license. We appreciate that. We don't want people lying to officers, but he did admit to not having a valid license. He also admitted to having a weapon in the vehicle. Again, we appreciate that. We want that. We don't want our officers finding loaded weapons. Now, as far as the question that, defense brings up, well, he detained him, he didn't arrest him after he indicated he was open carry. Well, he has to detain him because you can open carry and transport a weapon. He only indicated that the weapon was here. That weapon could have been in a locked case with the magazine out, the magazine into another place. So the officer has to verify, what does he mean when he says open carry? So had that actually been in a locked case, even though it really should not be within arm's reach, but if it was locked where he couldn't get to it and the magazine, there would be reason for us to say that this is not a CCW violation. But after he detained him and he further investigated, he recovered the weapon. It was not in a locked case. It had the magazine in it. It was loaded. So none of us like to see these type of cases. Obviously, the defendant was forthcoming, and they made the unfortunate mistake of urinating, and the officer, and not just urinating, but driving without a license, which then prompted further investigation. And it's unfortunate. A lot of people don't know how to transport their weapons, but this is the law. And so we might not like it, and even though we appreciate having a defendant like this who is open and forthcoming, as the testimony indicated, nothing was done wrong on the officer's part, but unfortunately, that weapon, that is not proper, and it is a sealed carry violation. We have a weapon within arm's reach of your person in a vehicle loaded. Therefore, we ask that it be found over as probable cause. We believe has been met. Thank you, Your Honor.
Okay. I'm not questioning whether or not it's illegal to carry a weapon in your vehicle without properly securing it in the lockbox, the trunk, or with the CPL. That's not the question here. The question is whether or not Officer Perry violated Mr. Jones' Fourth Amendment rights. And once again, video is showing something different than what testimony they provided. Officer Perry testified that he saw a vehicle, a Jeep sitting next to a vacant lot parked and running. That alone does not mean anything. I don't know what world or society, sitting in the car, with the car running, is suspicious for a reason to even begin to interact. And I know the wellness check is a good cause for officers to stop, and there are some officers who may be checking on individuals. You know, it's the police officer's job to also protect the community as well, not just find criminals and search for guns. But I don't believe this was a wellness check. I don't believe this was a wellness check. Officer Perry said it was occupied by 2 people. He spoke to them, seeing if they were okay. The video shows that the defendant and the passenger, not sure who was speaking. Let me get the words right. Officer Perry said, "Y'all good?" And the defendant and passenger said, "Yeah, me, myself," something to the effect of, "I just peed." Nothing funny is what I heard. I listened to it 3 times. And Officer Perry responded saying, "You can't do that." There was nowhere in the video that the defendant or the passenger stated that they urinated outside or in a vehicle or anywhere. I heard that someone just peed on themselves or just peed. Not sure what it was, but someone used the bathroom, urinated, but it was not stated where. So, based off of that, Officer Perry has justified everything that he did afterwards and based urinating in public as a misdemeanor and now a crime for him to further investigate whether or not Mr. Jones had a valid driver's license. And yes, the vehicle was running, and you do have to have a driver's license to operate a vehicle in situation, even if that means the ignition being on. And Officer Perry, after asking the defendant, if he had a license, the defendant said no, and there was further investigation. Officer Perry then said, asked if he was a CPL holder. The defendant said yes. And then later the defendant said, no, he's not a CPL holder, after Officer Perry got out of the car and approached the driver's side, but that he was open carrying. And then Officer Perry goes on to say that he pointed to his right side near the right leg of this person, and a black and silver was recovered. And once again, I say there's no question as to whether or not that was a carrying concealed weapon. However, I do not believe that Officer Perry had the right to search the vehicle or even question the defendant whether or not he had a license based off of information that the defendant or the passenger never said. Officer Perry's whole reasoning for stopping and searching the vehicle was based off of a misdemeanor that the defendant and or I'm not sure who was, the passenger never admitted to. So with that, I am going to dismiss without prejudice for insufficient evidence. And then to even say further, before I end this, there's an argument that this evidence would have been inevitable or it would have been found independent of Officer Perry violating their rights, Fourth Amendment rights, because he didn't have a driver's license. But that question was only asked after Officer Perry said that they committed a misdemeanor, which was urinating in public, which did not happen. So I am going to dismiss without prejudice, as I said, based on insufficient evidence.
Thanks, Judge. I do have one thing. I don't know if this is the appropriate time to ask for it, if this is even the right process. But with the case being dismissed, the police did seize Mr. Jones's firearm, which he was in the process of getting the CPL, had taken NSA classes. He just had to submit the paperwork. Is it the process that I can ask you, Judge, to sign an order telling DPD or whatever agency who has his firearm to return it to Mr. Jones?
All of it's registered to him. He doesn't have any, he's not a felon. I don't think there's any habitual notifications on here.
No, I don't believe, and that's, correct me if I'm
wrong. It may have been, the OIC was verified, so the defendant can indicate, like, but I don't believe that the weapon is actually registered to him.
Well, if it is registered, then yes, he's allowed to have it back. I'll put that in the order. If it's not registered, of course he can't.
Okay, honestly, Judge, I didn't check, so I candidly, I can't tell you, but I will, before I,
Very clear on the order. If the gun is registered to Mr. Jones, it's to be returned based on the case.
yes, Judge. Is that something you will prepare, or should I do a proposed one and send it to you?
If you
Sure.
can email it, I'll
Okay,
send it
sure.
right back over.
Thank you.
Okay, off the record on Mr. Jones, we have a lot of people who have been waiting. So the gentleman in Division 2, who just logged on, second, can you state your name, please? Say it one more time, I can't hear you.
Paul Anthony Rice.
Thank you, Mr. Rice. Attorney Robinson. Your client
I'm here,
is
Judge. I'm here.
Need to speak to Mr. Rice?
Pardon me?
Do you need to speak to Mr. Rice?
Yes, I would like to. Thank you.
Okay, Mr. Rice, I'm putting you into a breakout room so that you can speak to your attorney in private, okay? Trying to shriek into 40.
Hi, Judge, how are you? It's in the morning.
I know, I'm like,
Yeah.
you come on up.
Have you got my client on the Zoom?
Okay, let's see here. DeAndre Addison. Mr. Addison?
Yes,
Okay, good morning.
good morning.
And to Division 2. Attorney Harris still has not showed up for Mr. Mallory.
Do you suggest that? I
Yes.
spoke. We're slammed.
The audio went out, I didn't hear you. Say it one more time.
I was just asking if you suggest if we wait. We are slammed this morning. Do you anticipate his attorney coming on shortly?
No, but can you all log back in, or do you want me to just provide, or the court provides his new date or his PCC date?
If that's possible, if he's just, all they're doing is putting the date on the record, if that's possible, I would appreciate it.
Yeah, that's fine. So I will have the clerk send over his information once Attorney Harris logs on.
Thank you, Judge. Bye.
Okay. Okay, we are on the record. This is people of the state of Michigan versus DeAndre Antoine Addison, case 2256540. Mr. Addison is charged with 1 count of police officer fleeing, 3rd-degree vehicle code. The commission of a felony with a motor vehicle advisory. Today is the date set for a preliminary examination appearances.
Alexander Kirker on behalf of the people, P86282.
Morning, Your Honor. Samuel Sharikian appearing on behalf of Mr. Addison, present by way of Zoom. My G number is 29888. Mr. Addison, would you state your name, please?
DeAndre Addison.
Okay. Attorney Shrieky, is my understanding that your client is waiving his exam today?
That's right, Judge. Let me note that the officer in charge, as well as 3 patrol officers, are all present. I've seen them myself today. I know that people are ready to proceed. I conveyed that information to my client. I'm advising of the statutory right to a preliminary examination. Prepared to waive his exam, knowing to be bound over to the 3rd Circuit for disposition in this matter.
Okay, Mr. Addison, is that correct?
It was breaking up. I couldn't really understand y'all.
Okay, did your attorney discuss with you your right to have your preliminary exam today?
Yes.
Okay, and is it correct that no one threatened you or forced you to waive your exam?
Yes.
Did anyone promise you anything?
No.
Okay, I find your waiver to be freely, understandably, voluntarily given, and that's with no objection from the people, correct?
Correct, Your Honor.
Okay. So, Mr. Addison, I will have you bound over to 3rd Circuit Court for an arraignment on the information date of March 23rd at 9 a.m.
Okay.
Yeah, Judge, Mr. Addison, that's going to be at the Frank Murphy Hall of Justice at 9 o'clock sharp. Please give my office a call so we can discuss this matter further. Thank you, Judge.
Okay, thanks.
What's that, Mr. Addison? You can log off. Have a good rest of your day.
Thank you, you too.
Thank you. Okay.
Yeah. I would like to proceed with the next case. Everybody's holding.
Everybody's holding, okay. No, that's not.
Now, Ms. Howard has shown up.
Always. Okay, hold on one second here.
Ready on Rice, Judge.
Okay. Yes. Okay. Right next to. It's one, I have the one ending in 6-3. The other one ending in 502. Oh, okay. So is Baxter present?
Yes, ma'am.
With an attorney?
Yes, ma'am.
Oh. They're holding?
Officer, everybody's holding, Judge.
Okay.
Sorry, you said adjournment?
No, I'm getting the waivers on it right.
Hey, what's up?
That's gonna be a waiver. They're not all. Feliciana Johnson is gonna be a waiver. Baxter is attorney late, so.
Push it to the back.
Hmm?
So they'll come back at 1:30?
Yeah.
Okay.
I give it time. Did she just get here?
She got here about maybe 45 minutes ago.
At 9:30.
I think she's also on the three.
Four minutes.
Oh, she is. Okay. Yeah, we're gonna wait on that one. Let's do, Patrick Smith. And I can call Mr. Rice in the meantime. Okay, we're on the record, people of the state of Michigan versus Paul and Tony Rice, case 22-0502. Mr. Rice is charged with count 1, second-degree arson, count 2, arson, preparation to burn real property, with the individual offender second offense notice. Mr. Rice is also charged in case 22-60363 with the following: count 1, attempted second-degree arson, count 2, arson, preparation to burn real property, count 3, which is a misdemeanor arson of personal property less than $200 with the habitual offender second offense notice. Today is the day set for a competency hearing. Appearance.
I was zoning program, but on the people P86282.
And good morning, Sarah Robinson, P63181 for Mr. Paul Rice, who's present via Zoom from the Wayne County Jail.
Mr. Rice, can you state your name, please, loud and clear?
Paul Anthony Rice.
Thank you. I still don't have a report from Mr. Rice.
Judge, I spoke to the Forensic Center this morning. I can give an update.
Please.
I spoke to Ms. Lisa Muir at the Forensic Center. She indicated that additional time was needed to prepare the report. She did not give a date as to when the psychologist or psychiatrist would have the report done.
No type of range, 60, 30, nothing?
No. I would ask for a 30-day return.
Okay.
And if the report comes in, I would ask if I can contact the court to come back sooner if I get that report.
That works for me as well. So let's set it out to April 11th. And if we get the report before then, I will gladly, place it on the docket whenever we get it.
Thank you, Judge. As to bond, the court at the last hearing ordered a pretrial services report, DSU report. Has the court received that?
We haven't received that either. That's been a month. I put in another request for a DSU.
All right, Judge, may I argue bond, or does the court want that report first?
I would like to have a report, something. Let's see here. Two two 2206036 Okay, Attorney Robinson?
Yes, Judge.
So I don't know why the report has not been provided. I was just told by the clerk it will be ready in 5 to 10 days. Do you want to just set another date to address bond, or do you want to wait until April 11th?
I would like a date that's sooner.
Okay, so, today would be nice. We should have a report by the 16th. That's better than April 11th. Does 9 o'clock work?
What, March 16th, did you say, Judge?
Yes, March 16th to address bond with the DSU report.
All right, I'll be out of town that day, so I can zoom in. If there's no report, can we just get another date?
Sure, yep, that's fine.
Oh, okay. Thank you.
You're welcome. Anything else?
No.
All right, Mr. Rice, we'll come back on the 16th, hopefully with a report to address your bond.
Thank you. Thanks, Your Honor. Much appreciated.
You're welcome. Have a good rest of your day, sir.
You have a blessed day.
Thank you. Both of them 9 o'clock. Yeah, it was a waiver, but no pressure. I just want to make sure I didn't. Yeah, I got it. Okay, Mr. Kirk, we have time.
Your Honor, I'm sorry, did, this new, zoom in regards to the waiver?
Right, Ms. Johnson.
Yeah, it's Miss, she might be in the waiting room, and so.
She's here, she's under, Queen.
Oh, yeah. Oh, hi, Miss Johnson. So Your Honor, I just with Miss Johnson, and I'm very sorry, and we're very sorry to the court. Miss Johnson has had a change of heart. This morning, she was confident she wanted to take a plea offer, which is why we wanted to waive and have the matter bound over, which I did tell the people. And so that the people did call their officers off. I think, over the past few hours, Miss Johnson has changed her mind. She does not want to waive her right to an examination any longer. And we wanted to ask if the court could possibly schedule one more exam date for us. And also, we are very sorry for this.
Let me call the case. This is the people of the state of Michigan versus Feliciana Johnson, 2355546. Ms. Johnson is charged with count 1, controlled substances, possession of cocaine, heroin, or another narcotic less than 25 grams, set for an exam today. Appearances.
Good afternoon, or good morning, Your Honor. Daniela Parrish on behalf of the people, P85495.
And good morning, Your Honor. Neighborhood Defender Service by way of Emily New on behalf of Telenisha Johnson. My P number is 85234.
Ms. Johnson, can you state your full name for the record, please?
I'm sorry, I couldn't hear you.
Can you state your full name, please, for the record?
Feliciana Johnson.
Okay, Attorney New, can you state again what you stated off the record?
Yes, Your Honor. So this morning I did hear, so we adjourned last week because there was an offer the night before the exam that Miss Johnson wanted time to think about. This is her first involvement with the criminal justice system. And so she wanted to talk to her family and think more about it. This morning, she let me know that she does wish to take the offer. Just a few minutes ago, she called me to express that she's having second thoughts, that she does not feel comfortable waiving her examination, her right to an exam anymore, and would like to go ahead and hold the exam. We are very sorry for asking to change plans. And I did inform the prosecution this morning that Ms. Johnson did wish to take the offer. So they did call their officers off, and that is the defense fault. And so what we're asking for now is a defense adjournment so that we can hold the in-person examination.
Anything from you?
Yes, Your Honor. Defense is correct in what transpired. The OIC is here. Unfortunately, he let his officer go. They were en route here. He let his officer go within the last hour or so. I'm trying to see if we can get him back so that we can proceed with the exam today. But since they're on Zoom and they're not here and everything that's going on in court today, the people would not object to a brief adjournment. However, under normal circumstances, we would not, and we would like to put on the record that this offer will not be offered again, not at circuit court either, as we will note it into the account. Into the file. So we're happy to hold the exam, Your Honor, and as soon as possible.
How about March 21st at 10:30?
I can do that.
Your Honor, I'm just having my OIC check to make sure he's not on furlough.
Okay.
Unfortunately, the other officer is not here, but we can verify with him by today. If there is a problem, I can email the court immediately. Your Honor, did you say 10:30 on the 21st?
Yeah.
That works.
Johnson, your exam has been set for an in-person preliminary exam, March 21st at 10:30 a.m. If you decide you want to waive on that date, you are still to present yourself in person at 36th District Court. So we won't have this issue again.
Yes.
Anything else?
No, thank you, Your Honor.
All right, you have a good day. Good morning, thank you.
Good morning, ma'am.
Ready to go?
Yes, ma'am.
Okay. Attorney goes home, we're gonna take a 5-minute break. We've been going straight to 8:30. Then we're ready to go on your case. Mr. and Ms. Ripley, I'm gonna have your client's case called so you can log off, okay? Do a quick. Area. Okay, we're not on record, we're not court. When the court reporter gets back, let me log off.
I think that's all he heard when you said, we're gonna call your case so that you can log off. I think he just heard the log off.
I don't understand.
It's not going back. He was on the side here.
So it's fair to know that you, or who's gonna do the reoffending? They not.
Yeah, let me see.
All right, so far, ready? I don't know if you remember.
I do. Good to see you again.
It's been a while.
Yes.
That was 2014.
Right.
2014.
Yeah, I don't know if you noticed this, but, we can go ahead, I mean, and dismiss it without, Mr. If you don't need, the court doesn't need it here. That's what.
So we'll do that when the case is called.
Huh?
We'll do it when it's time for everybody else. Get the order of dismissal.
Okay.
We are on the record, this is people of the state of Michigan versus Patrick Devon Smith, 2355321. Mr. Smith is charged with 1 count of weapons carried concealed. They set for a preliminary examination. Appearances.
Good morning, Your Honor. Daniela Parrish on behalf of the people, P85495.
John Goldberg, P30758 on behalf of Mr. Smith. Mr. Smith, would you please put your name on the record?
Patrick Devon Smith.
Good afternoon.
Yes, sorry.
Okay, are all parties ready to proceed?
Yes, Your Honor.
Yes, Your Honor.
Any preliminary matters?
Your Honor, from the people, I would only indicate that, with the court, I have put defense counsel on notice that, based on the police report as well as the testimony we believe will be provided, the people will be inclined to add an additional charge. Again, we're just putting the court on notice if the
if and when the testimony warrants it.
Okay.
We been forewarned. I discussed that with Mr. Smith. Right, Mr. Smith?
Yes, ma'am, he discussed it with me.
And he understands that it's probably good and people could move to that.
Okay. Anything else?
Nothing for the people, Your Honor.
Okay, Mr. Smith, you can have a seat.
Oh.
If there's anyone on YouTube watching who may be a potential witness in this case, now is the time to log off. For the record, there's no one else in the courtroom other than attorneys, Mr. Smith, and staff. With that, you can go ahead further.
Thank you, Your Honor. People call John Anderson.
Officer Anderson.
I want that to be the next. Swear to tell the truth, and what you and nothing. Okay, have a seat. Make sure you speak up in the microphone, and whenever you're ready, swear.
Thank you.
Because I'm a little hard of hearing and I want court reporter here, thank you. Welcome to move the mic closer to you. You can put it on your lap if necessary. You can just speak in clearly with your answers. If I do ask you a question that you don't understand, please stop me. I'm happy to rephrase, okay? Same
Yes.
goes with defense.
Yes.
Thank you. Could you please restate your name for the record?
Police Officer Keywan Anderson,
And who are you currently employed with?
Detroit Police Department.
You indicated that your police officer is at capacity that you're employed with the Detroit Police Department.
Yes,
How long have you been a police officer, sir?
over 9 years.
Were you employed in this capacity on January 25th, 2023? Excuse me.
Yes,
Were you by yourself that day or with partner?
or partner,
What's your partner's name?
Officer Barone.
Were you in a scout car or on foot that day?
Scout car,
Was that a scout car fully or semi-marked?
black with yellow police lettering on both sides.
Thank you, sir. Were you in a full or modified uniform on that day, officer?
Full uniform.
That uniform include you wearing a functioning body worn camera?
Yes,
Did your duties as a Detroit police officer take you at or near Ward and Keeler Streets in the city of Detroit, County of Wayne?
yes.
Can you please tell the court why you were near or at said location?
Just driving down the street, someone patrolling between runs.
While at or near said location, did you observe something, sir, that drew your attention?
Yes, I observed the male behind you in the blue button-up shirt, braids, walking eastbound on Keeler, passing Ward.
Okay. When you observed this individual, can you tell us what you did when you initially observed him?
As I was driving, I illuminated him with my department flashlight,
Okay.
the spotlight on the vehicle.
And I'm sorry, I don't mean to cut you off, but I know you indicated, I just want to put it on the record, that individual, you do recognize them today?
I do.
Okay, could you please, again, for the record, indicate where this individual, if this individual is in the courtroom, where they are, and our code clothing knows them?
Your Honor, we stipulate for the purpose of exam only, he's identified.
Thank you. Officer, to continue, after you illuminated your light on it, could you please tell us what you observed?
I observed the front end of the front of his hoodie weighed down extremely heavy.
And could you describe, I know you said way down, heavy. Could you describe it in a little bit more detail?
Yes, ma'am. So like when I'm off duty, if I go to the gym and I wear a hoodie,
And normally I'll probably conceal my weapon in the same front pocket. Objective testimony, this is irrelevant. Question is, can you describe what you meant by worn down? The hoodie is weighed down by a heavy object. The
Did
hoodie
you
is
see
pulled.
that heavy object, sir?
Can you see the heavy object?
Can you see it, or could you describe, was it, you know?
So when the heavy, yes, ma'am. The object it's heavy, but it's leaning forward, like a forward motion. No, objection. That was not the question. The question was, can you describe the heavy object?
Leaning forward, I believe that's part of the description.
If you ask, can you make sure you answer the questions provided from the prosecutor?
Officer, based on that observation, can you tell us what, if anything, you believe based on your experience that object was?
Objection, Your Honor, calls for speculation.
This is based, Your Honor, the questioning that is going to come afterwards will show the reason why I'm asking this, based on why he would investigate any further.
That question could get you there. Why did he investigate further?
So to rephrase, officer, why did you investigate? Why, if you did you investigate further?
When Paul illuminated the defendant with my spotlight, he looked in my direction, immediately clutched the heavy item and stated, "What are y'all fucking with me for?" And then he looked back and he took off running, like across my car. So he was no longer going eastbound. He went westbound on Keeler and then northbound across the grass of like 3 houses on Ward.
So he began running from here, officer. What did you do at this time when he began running from you?
Well, ma'am, from my training experience, I believe he was armed. I then exited my patrol vehicle and I said, "Please stop. You better stop or I shoot your ass."
Okay. I appreciate your honesty. Okay, so after you warned the defendant to stop, otherwise you may shoot, what, did he stop?
No, he continued to clutch the item. I think he ran, I think it was the first but he got to the second house and appeared to about to go to the backyard. He turned in that direction, chucked the unknown item and turned around. At this point in time, he indicated what he's doing right now.
I can't hear him,
I'm
sir.
sorry. Objection. He's now doing a narrative. I'd ask me to go back to the questions.
Okay, it's becoming a narrative. Thank you. So, my apologies, let me stop you. So after you said he continued running, did you pursue him?
Yes.
Okay, while you pursued him, sir, did you observe where he went or anything he was doing?
Yes, he kept running. He was clutching the item still.
Okay. Did you continue to pursue?
Yes.
All right. During this pursuit, what, if any, observations did you make of the defendant?
He got to the fence area and chucked the unknown item against the house that he was running toward.
And you saw him, you say Chuck, so you saw him did you actually observe him make a motion of protest?
Toss him motion, yes.
So I see that you're actually, while giving testimony, showing us physically a motion of a throwing motion, is that correct?
Yes.
After you observed him chucking something from his person, you said, will you believe it's against a house?
Yes.
Towards a house, okay. Did you make any other observations, sight, sound, smell during that time?
Like I said, like a taking or clucking motion, like a hard object.
A hard object?
That's what I heard, yes, ma'am.
Okay, and this followed the chucking or at the same time? Or did you do that?
Follow the chucking, the throwing motion.
Once you observed the defendant chuck something from his person, you heard that noise, did you how much further did you continue after that observation pursuing the defendant?
He quickly stopped and faced me and we took him in custody.
Okay. So right after making that motion, he stopped voluntarily? Or
Yes.
when I say voluntarily, after all your commands?
Yes.
And once he stopped, and you said you took him, so you detained him, what, if anything, did you do after you detained him, sir?
Went back to that general area and conducted a canvas, called it out, multiple units came out to help me conduct the canvas.
And did you recover anything from that area?
Yes,
What did you recover, sir?
I recovered a black Taurus G2C 9mm handgun loaded with 8 live rounds, serial number 1 Charles 1 37673.
Sir, where exactly did you recover this handgun?
The driveway area, the driveway / black grass area of the 15416 ward.
Okay, so sir, where is that location that you recovered it in relevance to where you actually observed him chucking something?
The same direction, so the next yard over.
Okay, so same direction, when you say same direction of where, the direction of where he chucked something?
One house north.
Okay.
He was at the gate, was on the other side of that gate, right there in that backyard.
Okay, so, I know you told us what type of weapon. Could you give us a description of what the weapon looked like when you recovered it?
Yeah, the weapon the metal appeared to be damaged and chipped on the weapon.
Okay. You said damaged or chipped?
Yes.
In what way was it damaged? I'm trying to kind of picture how this was damaged.
Consistent with someone tossing that object and it hitting the ground and sliding, just like that.
Okay, so like a scratch, like a sliding, like a scratch, or?
Yes.
Okay. I don't mean to lead you, I'm just trying to get, I know you described a little bit more in detail, I was just trying to see what, if you could tell us without answer, I'm gonna take that question back. If you could just tell us, what the appearance of the damage looked like on the gun.
The damage on the gun was the metal was scratched. Some of the metal was like dented or consistent with someone throwing it and it hitting a hard object such as concrete.
You indicated when you recovered the gun, please restate first, was it loaded?
Yes.
Was the defendant at this time you know what, before I ask you that, let me just, sorry not to beat a dead horse, I just want to get a little bit more detail. I understand what you said about where it was in relation to the throwing motion. Could you tell the court distance-wise, like feet, maybe? I know I'm asking you something you might probably get a measuring tape out, but just for telling the court, like how far it was, like from this courtroom, so that we can kind of gauge from the point where you saw him actually make a motion, how far was that gun recovered?
Ma'am, I'm really not good with measurements.
I understand. Okay, appreciate that. So, was the defendant placed under arrest, sir?
Yes.
And just to return back to the pursuit. Again, like I said, I appreciated your bluntness and being honest. Did at any time prior to the throwing of the object motion, at any time did the defendant adhere to your commands to stop?
No.
Question's been asked and answered, right?
I didn't ask if at any time he had,
It's a variation of the question already asked.
I just wanted to clarify. Okay, so after the defendant was detained, officer, did you place the weapon and the ammunition from the weapon into evidence?
Yes, I did.
No further questions at this time. Thank you.
Sorry, Officer Anderson.
Yes.
Officer Anderson, you indicated that you've been a member of the Detroit Police Department for 9 years.
Yes.
And
where are you presently?
Second precinct.
And are you assigned, you indicated on that particular day that you were on routine patrol?
Yes,
And you were partnered with an officer, Aaron, is that correct?
yes,
And who was the driver of the car?
I was.
And how long has Officer Barron been on the job, if you know?
Don't know.
How long has she been your partner, if you know?
He's not really my partner. He was assigned to work with me that day.
Oh, okay. Who is your regular partner?
I don't have a regular partner, sir.
And are you assigned to any type of special unit at the second precinct?
I have been out there, no.
Okay, are you assigned to any special unit at this point?
No.
And so it's my understanding that you and your partner are on routine patrol. What time is it?
I don't remember. If I could refresh, 1:40. Approximately 1:45 a.m.
And would it be a fair statement that it was dark out?
The lighting was pretty good on that intersection.
The question was it dark out?
It was nighttime.
Okay, and you indicated the lighting was pretty good. Was that from the stars, the moon?
No, the side of the house, they had a side light there. Also, we were in the intersection where it was big street lights.
Okay, and you're at the intersection of which?
Keeler and Ward.
Now, it's my understanding that based on the question by the prosecutor, you were in a, let me put this way. How is your vehicle described?
It's
White being black with yellow on the side.
It's a push bar. We got lights on the top of the vehicle.
Now, the lights weren't on your vehicle at the time you made your observations, is that correct?
What lights?
Your tower.
No.
Okay. And when you first observed, because you've identified as Mr. Smith, how far away from him were you?
When I first observed him?
First observed in the car. You saw a guy walking down the street, you decided to flash your light on, correct?
Right.
Let me ask you a question, right, correct?
I don't understand your question.
Driving down the street, you see a guy walking down the street, correct?
Yes.
You then, no apparent reason, flash your light on, correct?
No.
Okay. Well, you indicated, sir, that you did put your light on him before any other action, correct?
That was not for no reason, sir. It's this protocol to see who I'm talking to.
So there was a reason.
Sir?
There was a reason.
Yes.
It's your protocol to just flash lights on people walking down the street, correct?
While I'm talking to him, yes.
Well, you weren't talking to him at that point in time, were you?
Yes, I was.
Did you have a conversation while you were in the car?
He engaged me when I flashed the light.
So you weren't talking to him when you flashed the light, were you?
When you say talking to, what do you mean, sir?
Sir, you said you flash the light on people when you're talking to them, correct?
If he's talking to me, I'm talking back to him, yes.
So you're saying this man was walking down the street, minding his own business, and started a conversation with you?
That's not what I said.
Sounded like you said. Anyway. Now, you indicated also that you were equipped with body cam.
Yes.
And what is the procedures with respect to initiating your body cam?
When police action happens, then I initiate.
Okay. When did you initiate your body cam in this particular case?
When he clutched the item and took off running during the pursuit.
So if I showed you your body cam, would that show that action?
I haven't seen the camera.
Right? That was my question.
I actually turned the camera on myself. So I had to, it's a button on the tab of the camera. That's what you're asking me.
And my question was, when you were chasing him, did you have your body cam on?
Yes.
You sure that?
Yes.
You sure it was recording?
What do you, at which point?
Are you
sir?
sure it was recording? It's a very simple question.
There's a recording, yes.
Would it surprise you if I showed you a copy of that body camera and you're not on that body cam until you're looking for a gun?
No, would it surprise me if
That's what your camera showed?
you show it to me?
My
Or so I can
question
refresh
was-
my memory?
My question was, would it surprise you if the body cam did not show what you just? Simple question.
I don't know the answer to that.
You told us you turned it on, correct?
I pressed the button, yes.
Okay. You don't know if it recorded, do you?
I'm not the technical aspect of it. I just
I
pressed the button.
understand that. Now, you indicated that you saw an object. Correct?
Sorry?
Weighing a heavy object.
Yes.
You had no idea what it was because you couldn't see the object. That's
true.
Everything that you're testifying to is speculation and your full experience. Correct?
I'm testifying to my training and experience.
Your training and experience. Now, were there any other objects that, oh, I'm sorry. When you were running after, where was your running?
I don't know. I was in front of him.
Okay. You indicated that other officers appeared at the scene later on, correct?
Yes.
Were those other officers present while you were allegedly chasing Mr. Smith?
No.
Now, it's my understanding that you jumped out of the car when he took off running, correct?
Yes.
And how far was this whole chase?
I'm not good at measurements. What do you, I'm
6 blocks, 3 miles, 50 feet?
2 houses.
2 houses, okay. So in that 2 houses, you indicated that he went between the houses?
No, he didn't go in between them.
So didn't you testify that when you found the gun, it was down between the houses some distance?
He angled his body.
My question was, didn't you testify that you found the gun down between 2 houses?
Yes.
Okay. And how far? I'm sorry. And you also testified that you observed him throw some object. Correct?
Yes.
Which hand did he throw? Right. Okay. And did he stop and take like a baseball or just flip it away?
Sir, it's just a chucking motion. In the middle of running, it's kind of hard to.
Yeah, I understand. And didn't you put in your statement that you found this weapon close by to the side of the wall?
I'm sorry?
Didn't you put in your report, you prepared a report this time, correct?
Yeah.
And didn't you indicate that you found the weapon close by to the sidewalk?
No, it's in the backyard of the driveway between 2 houses. Next to the driveway, but like right on the grass, but next to the driveway. So it's between 2 houses, as I testified to, sir.
When your report did you ever indicate that Mr. Smith came up, talked to you and said, what the fuck do you want or something like that?
He did not come up to me.
Okay. You testified today that he said something of that nature, correct?
Yes.
Well, did you put that in your report?
Sir, no.
And in fact, did you at any point in time put in your report that you told this man who was walking away from you?
He was not
Stop,
walking.
please, sir. Stop or I'll shoot you. Did you ever put that in your report?
No.
Thank you. In fact, that's against policy, isn't it?
No.
It is not against policy of the Detroit Police Department to get out of your police car and yell at someone, stop or I'll shoot you.
In the middle of a heated, encounter, there's no policy that states what I'm gonna say to respond to me feeling like I'm threatened.
Where was the threat to you? You had a person running from you with a heavy object in his pocket.
Sorry,
Is that correct?
sorry,
Is that
I'm not-
correct, sir?
I'm sorry?
Is that correct, sir?
I was threatened. From my experience, absolutely, I was threatened. I knew him to be armed.
No, him to be honest.
From
You
my,
have testified, sir. You have testified.
Judge, Your Honor, he has a question. Could you
I-
allow the
I'll let you
officer
answer.
to answer?
I'll look.
The last question was, how do you know him to be armed? Correct?
Your testimony, sir, was that you saw a heavy object in his wheel, correct? Pocket.
that wasn't the threat, sir. It was what he did that brought light to that heavy object as well as my experience, sir.
Sir, your testimony was he turned and he ran from you. Is that correct?
Yes.
Never drew any type of object out of his pocket, did he?
When he turned and threw it, he did. When he went at the gate,
You said that he was running and he chucked it. Where was the turning?
right after so it was almost simultaneous thing. Chucked and turned.
Oh, I see. So he chucked it and then turned around to his hand.
Yes,
You didn't put any of that in the report, did you?
I believe they can only refresh mark tonight.
Please refresh your memory.
Mr. Smith, the intern put his hands up and got on the ground when he was detained on the side of 15-4104.
Refresh your memory.
I was reading the report, sir.
No, read the report. Refresh your memory and answer the question.
Mr. Goldfarb, can you please step? to the
Oh, I'm
microphone?
sorry.
Thank you.
No point in time did you ever say that he chucked it and turned and raised his hand. Did you?
Yes, I did. He tossed a hard item, and then the next line was what I just read to you, sir.
Now, Mr. Anderson, you also recovered another object, isn't that correct?
So,
Correct. And did you recover the cell phone before or after you recovered the weapon?
I recovered the cell phone before.
Okay, and where did you recover the cell phone?
On the grass of one of the front lines he ran across.
Okay, and did you see him throw this weapon, or this phone down?
I seen the object drop.
Okay, and when you ran by it, did you see what it was?
I was busy focusing on him because his arm was still in his hoodie.
That wasn't my question. My question was, did you stop? The answer is yes or no?
Did I stop? Did I stop what?
If stop and.
No.
Go ahead. Now, where did you see this object fall?
Where did I see it fall?
Fall from?
I can't tell while I was running.
Did you just testify that the cell phone fell from his body?
From his person, I don't know if it was from his hand or pocket or what.
Now, did you see him toss his cell phone?
Again, the phone fell from when I was running. No.
Would you please look at your report to see what you put in there?
Yeah, I see the report, sir.
Did you indicate in your report that he tossed the cell phone?
No, this was about the weapon.
Sir? Did you indicate in your report I recovered his cell phone that he tossed during the foot chase in front of 154024. Is that what your report states?
It does.
So when you saw him toss a cell phone.
This is what I wrote at the time, is how I remember it, sir.
Okay. And in fact, when you were discussing these matters with your fellow officers about looking for the weapon, didn't you indicate that that's what you believed was a heavy object?
I don't remember what I talked about. If you can show me the video, sir.
And how far from where you found the phone did you find the weapon?
I do not recall, sir.
Now, when you made this observation about tossing something in an object, how far behind Mr. Smith were you?
Again, sir, I don't recall.
5 feet, 10 feet,
Sir, I'm not good with measurements.
2 blocks?
Excuse me?
2 blocks?
I'm not good with measurements, sir. Close enough to see the observations I put in this report.
And so how far were you away when you put your observations about him tossing the phone? Were you?
Again, sir, I'm not good with measurements. Close enough to see.
Did you toss the phone first or the gun first?
I'm sorry?
Did you toss the gun first or the phone first?
The phone was recovered. I believe the phone was fell from him first or whatever.
But that wasn't my question. My question was, since you made these observations and you said you saw him toss the phone, my question was, did he toss the phone first?
Oh, no, the phone was first. Yeah, I'm sorry. I misunderstood your question. I'm sorry.
By the way, did you take any statements from Mr. Smith at the end of this chase?
Statements as far as what, sir?
Did you talk to you? Did he give you an explanation as to why he was running?
He said that something about being robbed or somebody thinking about being the police before that.
So he told you he didn't know you were the police, is that correct?
Oh, no, he didn't.
My question was, he told you he didn't know you were the police, is that correct? But you may believe it's something else.
I'm sorry?
He told you he didn't think you were the police, is that correct?
If that's what you have that on camera, sir?
I didn't ask that question. My question was, you told me that he was talking to you. My question was, did he tell you he did not know you were the police? Yes or no?
I don't remember the full conversation, sir.
We look on the second page. Did you overhear any conversations with your fellow officers and Mr. Smith while you were looking for the gun or while you were being?
I don't recall the conversations at the scene, sir.
So at no time do you recall hearing Mr. Smith telling either yourself or fellow officers that he didn't know you were the police and that until the other officers in Mark Carson?
That's what I'm saying. I don't recall the conversations at the scene, sir.
What a question.
Couple questions, clarifying, based on the defense counsel's asking during cross. So, do you recall if you put the address of where the phone was recovered in your police report?
I do not recall. If I can check to refresh my memory.
Yes. Please let me know once you've refreshed your memory.
15402 Ward.
So 15402 Ward is where you recovered the phone.
Yes.
Did you happen to also put in your report where the location was that you actually apprehended the defendant, where he stopped?
Yes.
Is the address, or if you could please tell us what the address was of where he was actually apprehended, where he stopped?
Yes, if I can refresh my reports, then I can get the right numbers for you.
Sure, please. Once your memory has been refreshed, just let us know it's been refreshed, and then I'll re-ask the question.
He was detained on the side of 15410 Ward.
So we, the side of 15410 Ward, that's, you said immediately after you saw him toss a heavy object, correct?
Yes.
Okay. So where now was the, did you put an address for where the gun was located?
Yes.
Could you please tell us what was the address of where the gun was located?
15416 Ward.
Is that safe to assume that that's right next to where you apprehended him?
Objection. Call
I-
for speculation.
I'm asking, could you please tell us, it's not speculation to him, could you please tell us where that, if that was next to the place that you apprehended him?
Yes.
Final question, not final question, but final question in this line, of clarification. So at these locations, it came out during cross that whether the cell phone fell or tossed, however the wording was placed, I know under the testimony you indicated it fell from this person, or tossed, whichever one it was, okay? Can you tell us, did you hear any noise when that happened?
The cell phone?
Yes.
No, you see the black item just come from this person.
So when you testified that you heard a noise, can you clarify that was at the second toss? Can we say second toss since we were using this word toss or chuck?
Yes.
Okay, all right. So, and there was questioning on the direction of when you saw him chuck the, what you believe to be a weapon, okay? When you say you chucked it, can you please describe to us in what direction you saw the motion of him chucking this?
Yes, ma'am, can I stand up?
Sure, but if you could just talk it out while you show us so that the court reporter can get it.
Going northbound would have been across the lines. Going northbound would have been across the lines. Running northbound, slightly turning eastbound towards the backyard of where I recovered the weapon. A quick toss and a spin over to where we detained him.
Thank you. I appreciate that detail. So now we can see it a little bit more clear. And you said it was, the toss was towards the area of where you recovered the weapon, correct?
Yes.
I just wanted to, last question here. This question was asked, but taken back from defense, and I was curious, based on everything that you were indicating, as far as the line of questioning with the threat that you felt. Could you tell us what all made you believe that there was a threat to you, sir, please?
You're not going to object. This is well outside the scope of cross-examination, number one. Number two, he's testified as to what he observed, allegedly, and what he did.
Yeah.
He testified, Your Honor, that he believed there was a weapon, and because the man was running, that was a threat. Simple as that.
Actually, he did not testify like that. If anything, the officer stopped him and said he did not say that. So that's why I want the clarification, because there was many questions regards to a threat, but he did not allow the officer to give the full reason as to what made him believe that there was a threat.
I will allow it on redirect because Attorney Goldberg did get into the question about why he stopped or why he thought the defendant had something reason why he decided to pursue Jake. If you could please tell us what all was the reason that you felt that there was a threat.
Number one, man, my experience, if I can elaborate, I just got to the second precinct a month and a half ago. Prior to that, I worked the gang unit. I worked special operations before.
This is well beyond the scope of any cross-examination in this matter. He was working on similar acts. So in other words, as a member of the gang unit, I'm sure that they are on special patrol. That has nothing to do with this incident. And I specifically asked him if he was assigned to any type of special unit.
Previously, it was.
And I think this goes to his experience. Yes, he's giving a little bit more detail, but he's trying to explain what that experience is and why he believed there was a threat. You know, we're not officers out there, so I believe it's important to know why he believed, in totality, why he believed the defendant was a threat.
I just want to know, for this case, it's very important what he observed and he thought about this defendant, this day, this time. It doesn't matter how many other people he observed the week before. What about this case shows his reason and suspicion for stopping or chasing?
Officer, you heard the judge. If you could try to focus, I understand your experience, but if you try to focus that experience there, and the rest is the reasoning towards this defendant.
And you might not have a standing objection.
Okay, I'm sorry. Objection.
Oh, I'm sorry, I have a standing objection. That's fine.
Thank you. Officer, maybe, or your Honor, anything else?
Yes, you can answer over the council objection.
Yes, ma'am. I really don't know how to answer that question.
Your Honor, at that point in time, I'm going to ask you to stop this line of questioning.
I hear you.
I'm going to ask that you stop this line of questioning. He doesn't have an answer to the question.
I will
apologize.
rephrase. Okay, please. We told him if he doesn't understand something that we're happy to rephrase, I will rephrase. Aside from your vast experience, could you please tell us on that day, what circumstances made you believe that the defendant may be a threat to you?
When you first seen me, the way you looked at me, He immediately clutched the object. He took off running. He kept holding that object. Once he got to that gate, and ignored all my commands, he chucked an unknown object, a hard object in that driveway. He stopped. He put his hands up. Again, I've done these type of arrests many times. And I know him to be
Your Honor,
armed
at
based
this
off,
point in time.
there was a reasonable suspicion at this point, ma'am.
There are objections. As to his experience, I don't need to hear that.
I understand.
I want to hear only about this case.
I understand. Your Honor, the people would, I understand, but the people would like that he was saying based on his experience that he believed that he had. And I think that's important that his belief that there was a genuine weapon there, that can create a fear.
He said that several times.
Okay. Thank you, I appreciate it. And lastly, do you recall what the weather was that night? Was it cold, snowing? Do you recall by chance?
Your Honor, this is outside the scope of any type of cross-examination. All I asked him about was a dark color.
I can't hear him, sir.
Oh, I'm sorry. I will object. This is outside the scope of any cross-examination.
Your Honor, as he stated, he was asking about the appearance, if it was evening or whatnot, so I just wanted him to elaborate a little further, I believe, because we're questioning now things as far as.
The conditions outside.
Correct.
Okay. We know it started at 1 a.m. in the morning. I'll allow you to ask whether it's snowing or not, if it was cold or not.
Thank you, Your Honor. Please tell us if you recall the conditions.
Slightly snowy, it was cold.
And when you recovered, both, you said a gun and a cell phone. Did you have any, was there any further in these two locations, anything else observed around these two items that you recovered that goes along with everything you stated, goes across the?
Your Honor, that doesn't seem to be anything to do with cross-examination or direct examination. I don't object.
Your Honor, during cross, there was a lot of questioning that implied that there was some confusion as to the location and whether the cell phone was found first, whether the gun was found second. I'm just trying to see if there is any more information that he could provide the court to make it an easier decision for the court to prove probable cause. If you don't believe it's necessary, of course, I understand. But that is why I'm doing this line of question.
So he stated that he's not new distance several times. He gave direction and demonstrated direction defendant ran, how far to leave, not based off of actual guess, because the distance was where the gun was from the phone. Phone was dropped first. I believe that's what he said, correct? And then the gun or something dropped second, not necessarily gun. Later found out when he went or to observe at the gun. Is there anything outside of that that
I can move on to the question. Thank you. No further questions at this time. Thank you.
okay, you stepped down. Any other witnesses? Let's read.
No, Your Honor, none from the people.
What about the defense?
No, Your Honor, not at this time.
Okay. Ms. Parrish?
Thank you, Your Honor. People move the defendant Patrick Devon Smith be found over on count 1, weapons carried concealed. People would also ask that additional count 2, resisting and obstructing a peace officer, also be added based on the testimony received, and we reserve argument. Thank you, Your Honor.
Your Honor, this is a probable cause. And they have to show probable cause, not only that.
Oh, Attorney Goldwell, can you speak in the microphone?
There may be to determine whether or not there's enough to bind over on the. The evidence shows that Mr. Smith was walking down the street minding his own business at 1:45 in the morning. The dark vehicle, and it's dark now, there was some lighting according to Officer Anderson from street lights and house. And that they pull up on routine patrol and for no apparent reason shine the scout car light on Mr. Smith. There's some comment that is not in any of Mr. Officer Anderson's reports that there was some sort of discussion. However, Officer Anderson also testified that after seeing or allegedly seeing the officer or the gentleman getting out of the car, he turns, looks at him wide-eyed, and starts running from the area. It's at that point in time that Officer Anderson yells out, "Stop or I'm going to shoot you." He didn't testify, "Stop, I'm the police, quit running." In the middle of a dark night on a street in the city of Detroit, on the west side of Detroit, somebody gets out of a dark vehicle, yells, "Stop or I'm going to shoot you." The person who should have been fearing for his life was Mr. Smith. Now, as Officer Anderson said, "Oh, that's policy." Your Honor, I have never seen that type of a policy in the Detroit police officers' guidelines or any other area where an officer can jump out of a car and yell, pull his gun and stop or I'll shoot you. Right.
Before I shoot your ass.
Oh, that's right. I was trying to, before I shoot your ass. Oh, he doesn't know this man from Adam. He says, oh, he was in fear because he saw he saw a heavy object. We found out now there was at least another heavy object in that closet, which Officer Anderson said he saw him cross the phone. And he saw him cross the phone, like his testimony, prior to crossing the other heavy object. There's no testimony from Mr. Officer Anderson that he observed two heavy objects. And then he keeps chasing him for a short distance, I guess. We do not hear any testimony from Officer Anderson that other than "stop or I'll shoot your ass," that he identified himself as a police officer, that he identified him in any other way, shape, or form other than an individual chasing him down the street, going to shoot his ass. Your Honor, I believe clearly that the actions of the officer would indicate that there's no showing that he said, now he says he chucked an object. It's interesting because the gun is a lot bigger than a phone, and yet he still does not identify that he saw him throw away. For those reasons, Your Honor, I would ask the court not to bind him over on the CCW. Clearly, Your Honor, there is no evidence that even the probable cause to support any reasonable person to find that it was a resisting obstruction of justice. Thank you.
Yes, Your Honor, thank you. Your Honor, the testimony, to be clear, the officer was in his marked vehicle that he described the markings. There's lights on top. It says police all over it. It's 1 a.m. and he uses his flashlight to flash onto the defendant from this marked police vehicle. And he testified that after doing so,
The defendant turned to him, looked right over at him and said something along the lines, I don't want to quote him, why are you messing with me? Clutched his waist where the officer observed the heavy weighted object and turned and began to run from the police. So at this point, running from the police gives the officer reasonable suspicion aside from seeing the object in his hoodie. And he gets out of his vehicle and begins to pursue him. And yes, says those things that many of us may not like, but he did not pull out his weapon or shoot at him. And interestingly enough, there's no testimony that he shot at him.
I didn't say shot at him. There was testimony. He pulled out his weapon.
I did not hear that testimony on there. If that testimony is in there, I apologize. I'll take that part out. But there was no testimony that I heard that showed that the officer was actually going to shoot him as far as like shooting at him. But he did warn him that. Okay, he did warn him that he's going to shoot at him. It did not deter the defendant, did not stop the defendant, and he proceeded to leave. The officer commands you to stop, whether he tells you he's going to shoot at you, he's going to tase you, he's going to tackle you, whatever he's going to do to you if you don't stop, he is commanding you to stop. The defendant ignored those commands and continued to run. This is the officer indicated based on his experience and what he's dealt with, based on his belief that the defendant had a gun. Whether he did or didn't, this was what the officer believed. And he's now pursuing him in the middle of the night. He had fear. But this defendant did not stop at any time until he actually, as the officer indicated, chucked what he believed to be a weapon, but an object, over to another yard. Now, then he immediately stopped after he discarded what I believe what the officer believes was the weapon. He immediately stopped and then complied with the officer's order to stop. But at this point, he did resist and obstruct. There's an investigation. He starts running. Once he starts running, it triggers the fact that that officer has every right to investigate why this man is running. Aside from the bulge, the heaviness that he saw in his shirt. Now, he did not stop, kept running, officer pursuing him, he continued until he chucked the object. Now, because there was questions about the phone and whatnot, the testimony indicated the phone was found at 15402. Most of us all live in residential areas, know how addresses work in Michigan, but 15402, the phone was found. Corroborates the testimony that the phone dropped, tossed, whatever. No noise was made when the phone dropped at 15402. He continued to run after that, and he stopped, tossed into another yard, which is 15416, and stopped at 15410. People can assume, we could look it up, I'm not going to go into all that, but I believe there's probable cause here to show that he tossed it, exactly corroborating with the evidence that was testified to, into the neighboring home's yard, and he stopped at 15410 Ward and complied at that point and was detained. The gun was found exactly as the officer stated, where he saw him chuck it, and that's where it was found. The phone was exactly where he saw it dropped, in a yard prior to. It all corroborates. At this point, probable cause has been met. And we believe that at this point, the officer had full uniform on, his vehicle had markings that said police, and the defendant himself turned around and said, "Why you guys messing with me?" or something of that nature, and held on to where the officer believed the weapon was on his waist and began to run. At this point, probable cause shows that he likely ran to discard a weapon, and he does not have a CPO. So at this, we believe that most definitely there's been nothing that was asked of the officer
that would negate the second count that we asked to, for the resisting and obstructing. Once you start running from an officer and the officer tells you to stop and continue to disregard that command and keep running, that's resisting and obstructing. That's probable cause has been met there. And we believe that the totality of all the other circumstances that was testified to, the count one was all, the probable cause has also been met. We respectfully move that both count 1 and 2 be bound over. Thank you, Your Honor.
This case is problematic. Officer Anderson simply stated without any reason he was on patrol in between runs at 1:40 something a.m. rewarding Keeler in the city of Detroit. That he was in a scout car, black with yellow police on both sides. Push bar with lights that were not activated. And that he illuminated the light on the defendant. And that he saw the defendant with the front of his hoodie, as he described, way down and heavy. And that the defendant immediately clutched the items and said, "Why are y'all clucking? What y'all clucking for?" And then he began running. So my issue is right here. Everything else after that, the gun was, we can show probable cause, or I can see probable cause that the gun was likely tossed from the defendant, and that he did run from the police at some point. But right here, where Officer Anderson has testified that he illuminated a light at nighttime on the defendant, who was not doing anything wrong. He was not walking in the street when there was sidewalk provided, as a lot of officers use that as an excuse to stop. He was not littering. He was not urinating in public. He was not loitering. He was walking, doing nothing wrong, not committing any crime. The officer didn't even say, as some officers say, he was in a high crime area, which a lot of officers use that. Terry, totality of circumstances. I cannot find any facts here to show reasonable suspicion from the initial interaction. And the police can encounter civilians without there being anything wrong or any type of crime. But once the interaction begins, in this case, there was no interaction as words. There was no "hello, sir, how are you? What are you doing out here tonight?" The light was flashed. The defendant said, "What y'all fucking with me for?" Clutched his hoodie and began running. So you have the defendant clutching his hoodie and running, as I can see the only two factors that could be used towards reasonable suspicion that crime is afoot. There was no testimony that there was a gun hanging out of his hoodie. There was no testimony of the defendant stating he had a gun. Just because someone is holding onto their hoodie, and it's wintertime and it's cold outside, that means that they have a gun in their pocket, that they are committing a crime. It's not enough that the defendant ran because he saw a light flash on him at 1:45 in the morning in the city of Detroit and did not know. I can't say he didn't testify. Officers Anderson said he knew it was police, but there's no testimony saying that. That's questionable because the car was black with the markings on the side and dark. I do believe the defendant had a gun on him that he's not supposed to have, but however, it stopped in interaction. And to tell the defendant that if he don't stop running, he will stop running, he's gonna shoot his ass, based off of him only running, to me, has botched this whole case. So I am going to dismiss without prejudice for a violation of his Fourth Amendment rights and not, of course, add the second charge of resisting an restraint.
Thank you, Ron. You still on set? No, you want to wait for your paperwork? Mr. Wolf, you just let it outside, I'll figure out, so you can.
Mr. Jones, do you have a traffic matter?
Yes, ma'am.
Good afternoon.
Good afternoon, Your Honor.
You should be in judgment Williams courtroom. He's handling traffic matters now.
Okay, thank you, ma'am.
You see the Zoom information?
Yes, ma'am. Larry Williams, Judge Larry Williams.
Yes, sir. Go ahead and log on.
Yes, ma'am. I got it, ma'am. Thank you.
You're welcome.
Right, just like you have, what's it called?
Oh, the remarkable?
Yeah, so I was watching a YouTube video on.
Yeah.
And
I know that.
I was one, and there was a way for people to just transfer.
You do. You do.
What is the money?
I do. Sir, what's your name?
Robert Jolie?
Do you have a traffic matter?
No, it was like got tickets for a dog.
Oh, okay. So that's still, that's with Judge Larry Williams in court 332 now.
I don't know what that means. This is just the number that I got.
Okay. There's the information on the screen. Just go ahead and take it down and log in.
All right, just give me 1 second. Okay, thank you.
Welcome, sir.
All right, bye.
Okay, I'm ready to wait. Okay. Okay. Okay, we're on the record. This is the people of the state of Michigan versus Kimberly Wilson, who was defendant number 1, Latoya Denise Wilson, who was number 2, Victoria Wilson, who was defendant number 3, and the law Elton Perkins, defendant number 4, case number 2260378. Defendant 1 charged with count 1, robbery armed. Defendants 1, 2, 3, and 4 are charged with count 2, robbery armed. All defendants are charged with count 3, assault or assault and battery, with the habitual offender second offense notice for defendant number 4, Mr. Perkins. They set for preliminary examination appearances.
Alexander Kirker on behalf of the people, P86282.
Good afternoon, Your Honor. May it please the court, Carolina Sprinkle, P49898, on behalf of Laval Perkins.
And good afternoon, Tiffany Howell, P79667, on behalf of Victoria Wilson, who is also present in court.
Victoria Wilson. Good afternoon, Your Honor. May it please the court, Leanna Belcher, P80177, on behalf of Ms. Kimberly Wilson. State your name. Kimberly Wilson.
And Mr. Perkins, can you state your name for the record?
Laval Perkins.
Thank you. Good afternoon to everybody. Okay. I think the first thing we need to address is Ms. Victoria Wilson. Attorney McRipley was on, and that was her attorney.
No, I'm sorry, Judge, that's not Victoria Wilson. Victoria Wilson.
I think it was Latoya, Judge.
I'm sorry, Latoya Wilson. I'm sorry, it's a lot of Wilson. Okay. Latoya Wilson. And that is, or that was Attorney McRipley's client. He logged on earlier, and I believe, Mr. Kirker, correct me if I'm wrong, that APA intercession is okay with dismissing the case at this point without his presence or without his approval of a death, correct?
Yes, that's correct.
Okay, and for the record, Ms. Latoya Denise Wilson has passed away. I received information from the Tether unit, APA intercession received information, I forgot, from a different source. We've all had confirmation. She had, funeral was 2 weeks ago, 2 Fridays ago. Okay, all right, so, Mr. Kirker. With the dismissal. You have anything to say?
Nothing other than what's already stated, Your Honor.
Okay. So I will dismiss charges for Ms. Latoya Denise Wilson. That will be count 2 and 3. So with that, do we have any other preliminary matters?
Your Honor, I'm just asking for a order, see frustration.
Who's talking.
Oh, that's another thing. So we have to, because of the mask, plastic, if you all could state your name when you begin talking for the court reporter, it would make it a lot easier.
That was me, Leanna Belcher.
Thank you.
And just for the record, there is no one else in the courtroom other than defendant, the attorney. There's an officer in charge present, Mr. Kirker.
Yes, and I would ask for an exception for the officer in charge.
Objection to officer in charge sitting in.
No objections.
No, Your Honor.
Okay.
And is it correct, the officer in charge will not be testifying?
That's correct, Your Honor.
So for anyone who is on YouTube and watching proceedings at this time, if you are a potential witness or you think you may be testifying on this case, now is your time to log off. Any other preliminary matters?
Your Honor, just to put defense counsel and the court on notice that in the event that the facts so present themselves, the people with the add charges of assault with intent to do great bodily harm, assault with a dangerous weapon, and a felony firearm.
Based off of, okay,
Based off of the testimony.
that's just notice. It doesn't mean anything at this point, but appreciate the notice. That will be decided based off the testimony. So, with that, you can call your first witness.
At this time, the people called Derek Bryant.
All the way over.
Raise your right hand. You swear to tell the truth, so nothing but the truth. Make sure you speak up when you sit down, and you can hold the microphone in your lap. Whenever you're ready, Mr. Kerr.
Good afternoon. Could you please restate your name for the record?
Derek Bryant.
And I want to take you back to the date of October 15th, 2022. Do you remember that day?
Yes, sir.
Were you at or near the location of 1999 East Jefferson Ave,
Yes.
in the city of Detroit, County of Wayne?
Yes.
And were you also at or near the location of 1891 East Larned Street?
Yes.
Is that also in the city of Detroit, County of Wayne?
Yes.
Let's begin with the location on East Jefferson Ave. What brought you to that location?
On East Jefferson, I went to the room rented a room out there for the Valentine's Day.
And when you say rented a room, what is that location?
This is a hotel.
And what is your wife's name?
Alexander.
What happened when you arrived at the hotel?
I arrived at the hotel, I rented the room, I called her later on. Come meet me at the room.
And when you say called her, what are you referring to?
My wife.
And did your wife come and meet you at the hotel?
Yes.
And how did she arrive at the hotel?
She came with her cousin Kimberly and her cousin Victoria.
And you see her cousins present in the courtroom today?
Yes.
Could you please point them out, identify an article of clothing that they're wearing, and specify which cousin or who you're referring to?
I'm not mistaken, that's Kimberly to the left, to left of you, and Victoria to the right of you in the green jacket.
Your Honor, let the record reflect the identification of defendants. One and three.
You said Kimberly, did you describe something about Kimberly? I didn't hear what you said.
They got their masks on, so it's fine. I think just her over there to that right here.
Okay. Everyone for 5 seconds for the back down.
That's Victoria. That's Kimberly.
Just to clarify, the record reflect the identification of defendant one and defendant three. And what happened when your wife and Kimberly and Victoria Wilson arrived at the hotel?
She called me, I come down. I bought a coat like this. I had decked the whole room out with Valentine stuff. And she came in with Kimberly. Victoria, she was in the car.
I'm sorry. Just so you know, and you may miss up, when you say like this, you have to have the court reporter or the record describe what it is. When you say this, what did you mean? What type of coat or jacket?
This Detroit jacket like I got on right now. I was bringing this coat down to my wife to give it to her because I bought her a lot of gifts. I showed them on phone before they even got there. I showed them a whole lot of gifts that I had bought for my wife, outfits, coats. But this particular coat I brought down, and I was bringing this coat down.
And just to clarify, is it the same coat that you're wearing or is it a different coat?
Same coat.
Is this the same exact one that you gave to her, or is there another coat that you gave to her that looks like?
No, these are the same two exact coats. Same two exact coats. I had mine on and then I brought hers down on the hanger.
Okay, and just to clarify, the one that you gave to her, you are not wearing first.
Right.
First. And so what happens when you went to give her the jacket?
I was gonna give it to my wife, hand it to her, but Kimberly snatched the jacket and started running outside with it. I told her, give me my coat. That's for my wife. She said, fuck that, she taking the coat.
And did she have permission to take the coat?
No,
And did she return the coat?
no, as upon leaving out, she walked out the motel room. Upon walking out the motel room, I followed her out the motel room to try to retrieve my coat. And she was running around the car, then she pulled out a knife and tried to stab me with a knife. I don't know how she ain't stabbed me. She swung at me a couple times with it.
And when you say she, where are you referring to?
Kimberly. Because at the point in time, Victoria was just still sitting in the car at that point in time.
And can you describe the knife for me?
I don't know, nice little size knife. I got a knife, a folded knife. She, I said, give me my coat. She kept running around the car. At this point in time, she kept trying to swing the knife at me.
And when you say swing, can you describe the motion?
Swinging down at the knife like this, blocking with my arm.
And Your Honor, for the record, the witness is making a downward motion. And Russell,
So at that time, we tend to tussle for the coat. But I noticed she had like a firearm. She always keep her gun with her, so she had like her firearm, kept lifting it up like that. So I wasn't really trying to keep on trying to fight with this person because I'm really trying to fight with her to get my coat back. But she got this knife out.
I want to go back for a second to the knife. Since she swung it at you, how many times did she swing at you?
Say like three.
And how far away was Kimberly when she swung the knife at you?
Right in my face.
And how did you feel in this moment?
I really felt basically like betrayed because really she used to always come over my house and all this and all that, and I trusted her with coming over my crib. But when she started doing that over my coat that I bought for my wife that she was bringing, it kind of threw me off. I'm like, what the hell is she doing? You know what I mean?
And
So,
did you feel scared at all?
yes,
Were you scared that she was going to hit you with the knife?
yes.
And the firearm that you described, where was that located on Kimberly Wilson?
Like on her hip.
And did she threaten you with the firearm?
She threatened me with that a couple of times. Saying she'll shoot.
Just to clarify, who said she would shoot you?
Kim Wilson.
Did you ever pull the gun out?
No.
And what happened next?
She kept running around the car. We kept tussling, me yanking for the jacket. That's when her other sister, Victoria Wilson, got out the car. She started swinging, punching me in the face, they both trying to fight me over the jacket. They throwing the jacket to each other like it's a game or something.
And when you say swinging at you, what do you mean by that?
When she first got out, me and her sister tussling over the jacket, so Victoria come behind me and grabbed me by my neck or something, trying to pull me down to the ground, I guess. So we steady tussling for this jacket. And they steady trying to run in the car and throw it in the car, and she steady talking about, Kimberly Wilson steady talking about what she'll stab me and she'll shoot me and all such.
And so did they throw the jacket into the car?
Yes.
Okay, and what
She
happened?
threw it to her sister, Victoria Wilson, and Victoria put it in the car. While she steady out there trying to argue and fuss with me, intimidate me with a gun.
And what happened after the jacket was thrown into the car?
After the jacket was thrown in the car, they was both trying to get in the car and pull off. But my wife was trying to stop them from, because I guess they told her that they was gonna hurt me or something. So she trying to tell them at the same time while they trying to get me with the coat, she trying to tell them, let's just leave,
Objection,
leave.
Your Honor, you're safe.
The executive session.
Acknowledged, Your Honor. So if we could just limit the testimony to the statements that the defendants made or your observations, but not statements that other people made during this time.
After they threw the coat in the car, my wife was trying to indicate to them, let's leave. At that point in time, I had told my wife, I was like, why is you leaving with them? Because she told me, she said, they trying to hurt you. I was like, well, why would you leave?
And did your wife leave with them?
They end up, Kimberly Wilson kept telling her, bitch, you gonna take up for this nigga? Bitch, I'll fuck you up. You my cousin, I'll fuck you up. You gonna take up for this?
She said herself and her cousin. What was the cousin she was referring to?
Kimberly.
So that it,
While her being scared, she goes in the car with them.
And
when you say-
One moment. I need to go back. When you said, bitch, you gonna take us to the, you my cousin, who said that?
Kimberly Wilson,
Okay. To who?
to my wife, Alexandra Cole.
And then your objection, Attorney Sprinkle, was because there was no question on the floor, or is there something?
I lost it. I think it was going to be I think it was cause for speculation and he's speaking to the feelings of the other individual.
Okay.
He said, but she was scared.
Okay.
So I was just gonna clarify who I was referring to. When you said she jumped in the car because she was scared, who were you referring to?
My wife, Alexandra.
So Alexander got in the car.
Yes,
Did the defendants 1 and 3 get in the car as well?
yes,
Did they leave?
yes,
Did they leave with the jacket in the car?
yes.
And what happened after they left?
After they left, I called them and I told them to I said, bring my wife back to me or I'm calling the police. On my jacket and my properties back to me or I'm calling the police.
And did they return the jacket at this point?
No. They called me on the phone.
When you say they called you, who are you referring to?
Latoya Wilson, not here now. Kimberly Wilson, they called me on the phone and said, come and get your stuff and your wife.
And did they give you a location to come to?
Yes, they told me to come to their location on she was there
What was that location?
on Learning Street.
That's the 1891 East Lawrence Street
Yes.
address?
Yes.
What is that address?
That's their mother's address, Latoya Wilson. Right.
And did you go to that location?
Yes, I did.
And what happened when you were at that location?
While I'm going to the location, I come in and my wife come running up the stairs from the basement. It's, Victoria and Belle Perkins threw her down in the basement and started beating, stomping her.
Objection, Your Honor, that caused speculation. He indicates that he just entered the residence. He would not know what happened prior to him arriving.
And that would be third, did you see that happen?
No, I did not see it happen.
Then
I
it'll
was
be
just
sustained.
told
It'll be
I was
sustained.
speaking. But as
Hold
referring
on,
to
one
me, when I came in,
One moment, there has to be a question. When the objection's on the floor, you gotta stop talking, because you might not be able to say, based on the rules of evidence, that you don't have to worry about, but you may limit what you can say. Mr. Kirk?
And you stated another name, LaBelle Perkins. Is that person present in the courtroom today?
yes.
Could you please point out and identify an article of clothing she's wearing? Your Honor, let the record reflect the identification of defendant number 4. And what happens when you arrived at this address?
When I arrived at the address, I was greeted by all four. There was another guy I never seen that much.
When you say all 4, who are you referring to?
Kimberly Wilson, Victoria Wilson, Belle Perkins, Victoria Gray.
And what happened?
Upon me arriving, my wife come running up from the basement. And she's saying, why did you come here?
Objection, Your Honor.
Okay, I'm gonna stop. She said.
It's a lawyer's job, you don't, you don't have to do.
Upon entering.
One moment. So sustained on the hearsay. In the, Mr. Kirk will rephrase the question, so you can.
So what did you observe when you first got there?
I observed my wife running up from the basement. She come grab me and hug me. I'm thinking they're gonna tell me to get my things and we gonna go.
Yes, did you get your item, your coat back at this
No.
point?
I guess nothing back. Only thing I got was hit in the head with a bat by Latoya Wilson, punched and.
Let's go through each one of these things one at a time. So were you hit in the head with the bat first?
The back came like in the middle since I was there. When I first came in, she come in, my wife, Alexander Coach come in. They tell me, nigga, you gotta sit your ass down. They got bats, it's got Belle Perkins, Victoria Wilson, Kimberly Wilson, and Latoya Wilson. Belle Perkins.
They all said the same thing.
The Belle didn't say it, the girl said it, and the mother.
I'm sorry, Mr. Kirk, I
So when When I was told to sit down, that's when, Lavelle and another guy, Lavelle Perkins and another guy stood by the door with bats.
And which door did they stand by?
The only door you can go out, the front door that I came.
Front door, the only exit of the.
So when they sitting there with bats, Victoria Wilson started punching on my wife and beating her all through the apartment.
And when you say beating her all through the apartment, what do you mean?
Punching her, beating her, kneeing her, kicking her, stomping her on the floor, dragging her, stomping her, I mean, these police 10, 15 minutes straight just beating her, like that wasn't her cousin. I mean, when I say beating, I'm talking about beating. I had to sit in this chair and watch them beat her like that.
Were any threats made to you?
Yeah, sit down or I'll kill your ass. Y'all ain't getting out of here. I'm gonna kill your motherfucker.
And who threatens to kill you?
Kimberly Wilson, Victoria, and Latoya. I mean, Victoria Wilson and Victoria, Kimberly, all three.
And so were you hit at any point?
Yes, I was pushed and punched a few times. Hit.
Who pushed or punched you?
That was the mother Latoya Graves and Kimberly Wilson and Victoria Wilson.
And were these with closed fists that you were punched?
What's that? It's like closed fist or half closed fist, just swinging around, trying to get me to sit down and shut up.
And how many times do you think you were punched?
So, probably like 10 times, 10, 15 times.
And was it just with closed fists that you were hit?
No, that's when I was hit with the bat. When I jumped up, mother hit me in the head, Victoria Wilson hit me in the head with that. And all across my arms, shoulders.
And how many times were you hit with the bat?
15, 20 times.
And where were you hit with the bat?
Basically in my arms, because I'm trying like blocking it, because she kept swinging my head. So I'm really keep throwing my hands up. So she really catching my arms and hands. So I'm never really forward. When she hit me in the head with the bat, that's when I really was alert. Because I really because she kept trying to hit me in my face. But I wouldn't let her really like trying to catch me off guard looking this way, and she trying to hit me in the face, and I wouldn't let her.
And when you were being hit with the bat, how did you feel?
Frustrated.
And did anything else happen after you were hit with that?
Kimberly Wilson said, get them motherfuckers in the basement, we gonna kill them.
And were you brought to the basement at this point?
No, because they never took me to the basement. They, probably like 5 minutes later, they like, no, I'll get them motherfuckers out of here.
Were any other statements made prior to that?
Run this motherfucker pocket.
And when you say
Kimberly said, Kimberly, Latoya, and Victoria Wilson said, run this motherfucker pocket. And all three of them went to run it,
By running your pocket, what do you mean?
took my money. Went in my pockets and taking my money, telling me don't move, but they got pistol on the hip, and pistol in the hand, and Perkins standing there with a bat, with him and another guy looking at my eyes, if motherfucker move, I'm gonna hit you, crack you with it.
So who made the statement that they would hit you with that?
No, I said they was looking at it like that, 'cause they both got bats standing at the door, he never said that. He just standing there with the bat at the door, like, shh, you do anything, you know, I'm crack you in there.
And you said there were other weapons that were present as well?
Knife, gun, bat.
Who had the knife?
Kimberly Wilson had a knife and bat. And a gun. She had a gun on her hip. She always had a knife, like she had a knife in the room. Bill standing there with the bat. Upon him standing there with the bat, he was told by Kimberly Wilson, to go out to the car and get his belongings, get whatever he got out of the car. So Lavelle Perkins and the unknown other guy that was there, I don't know his name, they went out to my car and broke my.
Objection, Your Honor, calls for speculation unless he was outside. He doesn't know what's occurring out there.
I didn't know it was
One
coming out
second,
there.
one more. Objection. That's lawyers. Mr. Kirk, can you clarify whether?
Did you observe Lavelle and this unknown other to go through your car?
No, they told me when they came back in the house.
And who told you when they came back?
Lavelle Perkins and the other guy come up in the house and told me what they took out the car.
And what did he say he took from the car?
Money.
You know how much money was taken from the car? 200 to 300, $300. And you said money was also taken from your person while you were in
Yes, it was took from my person when I was in the house. My first arrived in the house.
you know roughly how much money was taken from the house?
Like 2,000. Maybe a little more.
And again, just for clarification, it's $2,000.
$2,000 plus.
And you know who took the money when you were in the house?
All three of them was digging in my pockets. Victoria Wilson, Kimberly Wilson, and Latoya Wilson. They was just standing there at the door. In the back.
And what happened after Lavelle and the unknown other returned to the car?
Every time from the car, they just said what item they took. Continue standing by the door.
And this was just to go back, just money?
Yes.
And did anything happen after that?
After that, Victoria just kept on, beating my wife and dragging her around. But they all just living off, just watching their cousin, watching their duties. And that shit.
Right. It's not in court. It's not a quote, someone said, please, right.
Right.
Thanks.
And during this whole interaction, were you afraid?
Yes.
Fear for your life?
Objection,
Yes.
leading.
How did you feel?
How did you feel during this?
Afraid and fear for my life and my wife's life at the same time.
One moment, Your Honor. So when you were talking about them going into, well, the valve is on them, on their going into your car, you mentioned a glove box was broken.
Yes.
Was the glove box, broken prior to them entering the car?
No, the glove box wasn't broken prior to them going to the car.
I have no further questions, Your Honor.
I do. Yeah.
Sorry, I don't. It's so short. They look at the.
Closer to her.
Yeah.
Did you all say it's cold?
Yeah, yes.
I'm comfortable.
I'm always hot.
It was super hot in the hallway, now it's cold in here.
Is it cold?
So, I know, but I'm putting it on.
That's how I feel.
Okay.
Whenever you're ready.
Thank you, Judge. That's gonna be right. So, I have some questions for you. Want to clarify something. Now, you just checked. For the record, this is Attorney Tiffany Howell. Mr. Bryant, you just testified that at the motel, you went to Comfort Inn, correct? When the incident occurred?
Listen.
I'm asking a question. You went to
Yes.
Comfort Inn, right? Okay. You stated that you went out to the car to get your jacket from Kimberly, correct?
Mhm.
At that time, Victoria Wilson was still in the vehicle,
Yes.
but at some point, Victoria Wilson got out and was swinging at you?
I said she got out and grabbed me around my neck.
Okay, so she
She
took
was
her,
trying to help her sister grab the jacket.
okay, so she,
And help her retrieve the jacket, yes.
okay. So, do you actually remember what happened this day?
Yes, it
Okay,
happened to me.
absolutely, and so just sure with everything you're saying right now?
Yes.
Okay, and she came up behind you and grabbed you?
Yeah, from what everything was going on, she got out the car and I believe she grabbed.
Okay, and who took the coat from you?
It was like I handed the coat to my wife in the inside of the motel room, in the lobby. I handed it to my wife and Kimberly, I think my wife handed it to Kimberly, right? So when my wife handed the coat to Kimberly, Kimberly tries to run out with the coat. I said, give me my coat. That's my wife's coat. She said, I'm keeping the coat.
Let me stop you for a second. But at some point, you testified that Kimberly took the coat and gave it to Victoria inside the car, correct?
When I say she took the coat from outside the possession of my wife, gave it to her. When my wife gave it to her, I said, give me my coat.
Then what did she do with the coat?
And she ran out with it. I followed her back outside to go outside and said, run, give me my coat.
And then what did she do with the
Where
coat?
she kept going with the coat, telling me I'm keeping it.
Okay, hold on. Did she hand the coat to someone else after?
I don't remember her handing nothing. She didn't hand it to me.
Did you see her hand it to Victoria?
I didn't see her hand nothing to nobody. As everything going on,
Okay.
I wasn't worried about
Hold on.
to who.
Okay.
I'm worried about you handing me my.
Mr. Bryant, I asked the question, you only answered. Okay.
I'm just trying to answer your question. I said, I asked you to hand it back to me.
Mr. Bryant, so the nature, this is cross-examination. They're going to ask very specific questions. Most
But I asked them.
most of them will be yes or no, there was some that won't be.
Okay.
But just keep it to what they're asking, and Mr. Kirker, the prosecutor, will have the chance to follow up and clean up anything that needs clarification, right?
Mr. Bryant, yes or no? Did you just testify and told the prosecutor that Kimberly took your jacket, ran outside and gave it to Victoria? Did you just say that, yes or no?
Yes,
Is that true, yes or no?
that's true.
So you saw Kimberly hand Victoria the jacket, yes or no?
I can't say yes or no to that.
So you did not see it?
I did not see it.
Okay. Now, isn't it true?
I know there was, hold on, let me take that back. Let me take that back.
Is it yes or no?
Yes.
You saw with your two eyes, Kim
I
take
ain't
the,
said it. Go ahead, finish your question.
you saw Kim, right here, hand the jacket to Victoria. Yes or no?
Let me clarify.
No, it's a yes or no. Did you see it? Yes or no?
I saw them throwing the jacket back and forth to each other, let me say that.
Okay, so you say throwing, are you talking like?
Tossing to each other, other than me, and I'm asking.
I'm gonna demonstrate to the court. I'm gonna throw this hat to Attorney Belcher. Catch it. Throw that.
There you go.
This is what they're doing?
That's what they were doing.
And you sure about that?
I'm positive.
Mr. Bryant, isn't it true that when Kim first took the jacket, you and her were playing and joking around? Yes or no?
No, it wasn't no joking.
Isn't it true that when you went outside, you and Kim were running around the car playing with the jacket?
No.
Isn't it true that your wife was playing along with you guys, keeping the jacket from you?
No.
Isn't it true that your wife is the one who actually took the jacket and not Kimberly?
I handed it
Yes
to
or no?
and Kimberly.
Yes
I
or
handed it
no?
to my wife and Kimberly
Yes
took it
or
from my
no?
wife.
Okay, Mr. Bryant. Judge, I'm gonna go ahead and play the video.
There you go.
Mr. Bryant, the commentary, you have to only answer questions, okay?
Yes.
We're still in court.
And just for the record, your testimony today has been truthful?
Yes.
Okay, and according to you, you remember everything, correct?
Yes.
Judge, can I just move? There's a glare from where I'm sitting from the light. Thank you.
Mr. Bryant?
That help?
A little bit. I think it's that light, Judge, that's causing the glare.
I don't have to switch that. What's that one? Okay.
Mr. Bryant, do you recognize, take a look at the screen, do you recognize this steel shot right here? That I have on screen?
Yes.
What is this? Where is it?
That's in the parking lot of the motel room.
On the day in question?
Yes.
Okay, can you tell me who is the person wearing the blue outfit? Do you recall what your wife had on the incident?
No, I don't recall. That was so many months ago. I don't recall that. That's why I got.
Do you recall what any of them had on?
Actually, 5 months ago, no.
Do you know who the person in the pink is?
Wanna get closer up to.
Go ahead, there's the most you need to.
Oh. Yeah. Okay, now I can see everyone.
Okay, who's the person in the green? Can you identify that person for the court, please?
In the what color now?
I'm sorry, in the blue.
That's Alexander.
And that's your wife, correct?
Yeah.
Who's the person in the pink?
say, I would say that's Victoria.
That's Victoria?
That's blurry.
The person in the pink is Victoria?
I said I got blurry eyes, I can't really see, I just see a blurry vision. I need to blow up a little bit.
Hold on.
I really can't see the face. I know what my wife is like, but I don't know if both of them shape the same.
Okay. Is there any physical differences between Victoria and Kim? Is one plus size and one not?
One bigger than the other.
Okay, who's bigger?
Victoria Wilson.
No, you say bigger, is she like just a little bigger than Kim, or is she considered a plus size woman?
I'm just saying she's a little bigger.
Okay, all right. Okay. Judge, 1 second, please.
But you play the video, I would know what's
Okay, that's not. Judge, I would like to make defense exhibit 1 and play for the court.
Any objection?
No objection, Your Honor.
You just notified second wise when you started to stop.
Yes, yes, I will. So right now, it's 0 seconds. I'm gonna go ahead and press play. To display Mr. Bryant to see if he can recognize the video. But we do, for the record, he has stated that the woman in the blue is his wife, Alexandra.
That person is Victoria. I mean, not Victoria, that's Kimberly Wilson.
Okay, I just paused it at 8 seconds. The person who is wearing pink and who just entered, sat beside the driver's seat, that is Kim?
Yeah.
Okay. Press play, Your Honor. Okay, and just pause it right a second. 29 seconds. Did you just see what your wife did? Just for record, did it appear that maybe she asked Kim to wait a second, put her hand up and her finger saying, wait for a moment, and she walked away?
She just went over there and verified the car was driving, it was parked right over there. She went.
Okay, so the question was, did you see her lift her hand up and like a finger telling them to wait? Okay, so she's telling her hold on to wait, okay. Press and play at 30 seconds.
Why leaving? That's not playing, that's me asking.
I didn't ask you any questions, Mr. Bryant.
Brian, you have to wait for a question.
We're gonna just watch the video, it speaks for itself. I'm gonna pause for a second at 2 minutes and 35 seconds. Mr. Bryant,
Oh, you
oh,
got
I'm
that.
sorry. Wait,
Pause it.
it's a lack. It's paused on my computer.
Oh, okay.
Wait, no, there you go. I just paused it at 2 minutes and 43 seconds. Mr. Bryant, did you see Kim hand her jacket to someone?
No,
You didn't see that. You didn't see the back door open? Let me rewind it back for you. Judge, I'm gonna take it back a little bit. But that's it, I'm sorry. Apologize. Right. Pause, 2 minutes and 5 seconds. Mr. Bryant, who gets inside the back seat of the vehicle?
my wife.
So that's your wife on the back seat of the vehicle. Okay, I'm gonna press play. And pause, 2 minutes and 6 seconds. Did you see your wife wave her hand just now?
No.
I'll remind it for you. Oh. Pause, 2 minutes, 5
That's not a
seconds.
wave. I don't know what you call it.
Okay, press play.
No, I didn't see her wave.
Okay, press play. Pause, 2 minutes, 29 seconds. You just saw the door that your wife was on the car and the back seat just open, correct?
Correct.
Playing. I'm gonna pause it now. 2 minutes, 33 seconds. Who has possession of the coat right now, Mr. Bryant?
Alexandra put it in the car.
She has possession of the car, the coat. That's her gift, her coat, she has it. Okay, I'm gonna press play. We'll finish watching it. I'm gonna pause it right here. Oh, I'm sorry, Your Honor. No, I'm not. I'm gonna pause it here in 4 minutes and 20 seconds. Mr. Bryant, did you recognize the person who just stepped out of the front passenger car? Side of the car? You know who that is?
Yes, that's, Victoria.
Okay. Present play, Judge, record.
That's when my wife was telling them to.
No questions,
She
Mr. Bryant.
back.
I gotta wait for the question.
I'll pause it right here. 4 minutes and 58 seconds. Is that you and your wife fighting?
Oh, man, my wife wasn't fighting.
Okay, thank you.
My wife was telling them
Mr. Bryant,
to give him his
Mr.
coat
Bryant.
back and before they hurt
Mr.
you.
Bryant, this is my cross-examination. I ask the questions.
Like I said before, Mr. Perkins will be able to ask any questions, tell your story, and explain anything that you don't need to ask of you on cross-examination.
So just to ask before we continue playing, Mr. Bryant, at any point, did you and your wife start fighting?
No.
That's right. So I'm gonna end it here, at 8 minutes and 52 seconds. That's all. And Mr. Bryant, you saw the video, correct?
Right.
And this is surveillance video from outside the hotel where this fight happened.
Right.
Okay. And it was your testimony that my client Victoria was swinging at you and punching you. But that's not shown in the video, now is it?
Well, she swung at me a couple times and grabbed me around my neck, so yes.
Now, is it also shown in the video, you fighting her sister when all three ladies were in the car?
No, I wasn't.
So that wasn't on the video?
No, I was
Okay.
just telling him to give me
Now,
the thing.
did you see the part where your wife,
Fighting, I've been punched.
okay, did you see the part of the video where Kim hands your wife the car, the coat, she opens the door and she takes the coat, you see that part?
Yes.
Okay, so did you see at any part Kim handing the Jordan jacket?
No.
Even though you testified that's what you saw with your own eyes and you're sure what you saw.
Yeah, I kind of thought that, but the video show.
And the video also showed you and your wife fighting, correct?
No, we would never
You
fight.
didn't see that part?
Never saw no fight.
You
My
have
wife
a
was telling me
history-
to get away from them because they're trying to hurt you.
Do you have a
That's all
history
she
of
was
fighting
saying.
your
She
wife?
was pushing me back. We would never fight. That was no
Listen,
fight.
we
It's
saw-
fighting me and hitting.
We just watched the video.
Why would me and my wife fight a week at a ring?
What's the answer?
Mr. Brand,
No. that's-
Okay, do you have a
no.
history of fighting your wife?
No.
Objection, not relevance.
He made it relevant when he said he done with fight, never fought.
Relevance.
And it goes to credibility as well. But, I mean,
I saw the video and I can see what that was. I don't even know what they done before that day, before after.
now, Mr. Bryant, it was your testimony that your wife was taken against her will?
At some point, yes.
At what point?
Later on down the line.
When? When did you see your wife
I
being taken?
I didn't see it. I hear it on the video.
What video?
Speak about that a little bit down the line, I guess.
Mr. Bryan, did you see another video that other than the video I just shown?
No,
So what video are you referring to?
I'm just referring to this for now.
So my question is, did you see your wife ever taken against her will?
You can't hear.
Question yes or no? Did
Yes,
you?
yes.
Okay, when did you see it? Are you referring to the video I just played
I'm
outside the motel?
Can I talk? You can let me talk. I can step and cut me off if you let me talk.
You can answer my question, that's what you can do.
What was going on right there was them, my
My
wife telling
question is
me.
very simple to you.
My wife telling me.
Mr. Bryant, listen, we're gonna be here all day, okay?
Yes, yes,
So you saw on this video I just played for the court,
yes,
your wife being taken against her will.
yes.
Okay. Next question. You stated that you received a call, I'm sorry. You stated that you received a call from LaToya and Kim after your wife drove off with her cousins?
Yes,
You also testified to seeing Victoria Wilson beat her cousin. Is it true, is your testimony that you saw Victoria Wilson punching, beating, stumping?
yes,
And you testified that she was beating her like she wasn't her cousin?
yes,
Okay. And is it safe to say this beating left an impression on you?
yes, it left an impression on me.
Is this something that you don't think you'll ever forget?
Never.
Then why didn't you tell the police in your police statement?
I did tell her.
So your testimony, you told the police in your police statement that Victoria beat, stomped, kicked, punched, and was beating your wife.
If I did, then, no, I probably meant, I don't know, I think I told her.
Yes, yes, no, did you tell her
It's
that?
been so long ago, I don't know if I put
Mr.
that part in.
Mr. Bryant, you just testified that you remember your memory's good and you remember everything, and this left an impression on you.
I'm just telling you,
So-
I don't know if I put that part in, so
Okay.
I don't know.
Okay.
But,
Do you remember going to the police station and meeting with a Detective Earl? Are you Detective Earl? Detective Earl, right here.
yes,
You don't talk to him?
yes,
Okay. And you remember making a statement to the police?
yes,
Do you remember writing the statement and signing it?
yes,
Did you read over it after you wrote it out?
yes.
Okay. May I question, Mr. Honor?
Yes.
Can you pan I'm sorry, can you tell the court I just handed you? Can you tell the court I just handed you?
Tell them what?
Tell the court what's in your hand, what did I just hand you? I hand you a paper, correct?
Yeah.
It's 3 pages, correct?
What can you tell me about?
Is it, Mr. Bryant?
Mr. Bryant, what do you have in your hand?
Statement.
Is it your statement?
Yes.
I want you to quietly read over your statement and you tell me if you see your statement to the police about this severe kick and punch and stomping that Victoria Wilson did to your wife.
No, I don't see it out here.
Okay, thank you. I'll take those. So you never told the police about this severe beating you witnessed? Yes, no?
I'm pretty sure I said it.
Even though it's not in your police statement that you wrote when this incident was fresh in your mind?
It probably was.
I wasn't done with my question.
It probably was said.
I was not done with my question.
Wasn't wrote in, but.
I wasn't done with my question.
Right, let her finish your question. Whether you like the question or not, let her finish it.
This police statement you gave to the police?
It's not in there, no.
Okay, and you read over the statement?
Yeah.
And you made sure it was accurate and complete?
It's not accurate, but it's.
Okay, but you signed it, correct?
Yeah.
Okay. And this is when this happened the same day as the incident, correct?
Yeah.
Okay. When it was fresh in your memory?
Yeah.
One second, Judge. Okay, no further questions. Let me try. Oh, did you need the video?
I don't think so. All right, good afternoon, Mr. Bryant. My name's Leanna Belcher. I'm also going to ask you some questions, okay? It's going to be the same format. I'll ask the question, you answer. If you don't understand my question, let me know and I'm happy to rephrase, okay? All right. Sir, on this date and time that you went to the hotel, I believe you indicated you went there alone and rented the room. Is that correct? And prior to you getting there, had you consumed any alcohol that day?
No.
Had you consumed any narcotics that day?
I don't do narcotics.
You didn't smoke any weed that day?
I don't smoke weed.
Okay, fair enough. It's just a question. I'm not saying you did or didn't. That's why I'm asking, right? And I believe you testified that you purchased that jacket for your wife, right?
Right.
It was a gift for her? And your intentions were to give it to her that day, and then it was gonna be her jacket, right? And I know we watched the video, and I know Ms. Powell asked you a lot of questions about it. I think we can move on from that point. And I'm gonna focus on when you went to the residence after the hotel, okay? On your way to the the residence, did you have a cell phone on your person?
Yes.
Did you call the police?
I called the police, well, I didn't call the police, the room called the police.
Sir.
I didn't get a chance to call the police because the room called the police. No.
You're
no.
making it really painful.
No.
It's really simple. Did you call the police on the way there? Okay, that's all I'm looking at. He's gonna have an opportunity to ask you more questions, okay? So we'll get through this a lot faster if you just answer what I'm asking. Okay, so you didn't call the police on your way to the house. When you arrived to the house, did you call the police?
I could have called the police when I got guns and knives.
Sir, you're making it, okay, no, you didn't, okay. You had a phone on you though. You had your phone, right? Okay. When you go into the house, I believe you testified today that all three defendants in this courtroom were yelling things out in unison. I believe you testified that you were pushed and punched by LaToya, Kimberly, and Victoria. Is that true?
Yes.
Okay, now let's go back to your statement, sir. I haven't seen it. Judge, may I approach?
Yes.
Thank you. Take a sir. I know you already read over that statement, but can you look through it one more time for me and just look up when you're done?
Ask your question.
Sir, that's not what I said. I said, can you look at it?
I just got finished looking at it.
Okay, but can you look at it again?
Okay.
Thank you. Can you flip through all three pages, because there's a couple pages there. Sir, I was looking at that, refresh your recollection about what you told the police.
Yes.
Okay, and isn't it true, sir, that you did not tell the police that you were pushed and punched by LaToya, Kimberly, and Victoria? In fact, you only told the police that LaToya hit you with the bat?
I would say yes, part of the statement.
Okay. So you're admitting that you only told the police during that interview that LaToya hit you with the bat, correct?
Yes.
Okay. I have that back. Thank you.
You're welcome.
And you make no mention, I believe you testified on direct that my client Kimberly had a gun, a bat, and a knife all at the same time, right, when you were in this house? You make no mention of that to the police, do you?
I didn't put it in there.
Do you want to look again to see if it's in here?
No, I didn't make no mention
Okay,
of
so
that.
it's not in there. And Mr. Bryant, you were previously convicted of a crime of theft and dishonesty in 2017, right? Out of Wayne County.
Larson?
So that's a yes?
Yes.
Okay. No further questions.
Good afternoon. I'm Attorney Sprinkle. I represent Mr. Perkins. And I'm not gonna argue, so we're just gonna do 3 questions. Okay. Testimony today is that Mr. Perkins only stood by the doorway holding a bat. Yes or no?
Yes.
And you also testified that there was another individual that stood by the door and he was holding the bat as well. Yes or no? And the identity of that gentleman is not known to you, is that correct?
Yes.
Okay. And your testimony finally was that from where you were seated, you did not see what took place outside of the house with regard to your vehicle.
Yes.
Thank you. No further questions.
Just brief, Your Honor. Did you have an opportunity to speak with police at the hotel?
Yes, I did.
And what was that conversation with the police?
I told the police that I just had my coat took, and my wife, coat took, and my wife was, they took my wife with them. And, it was calling, Latoya and Victoria.
Objection, Your Honor. I believe this question is outside the scope of what our cross-examination was. We never asked him what he said to the police on the scene. We just asked specifically about the statement he made in the interview.
There were questions about whether he called the police when he was at the hotel, and that he was not the one who called the police. And so I just wanted to clarify if he had an opportunity to speak with the police.
So the question should be, did you speak to the police? Is yes, you did, not going into what the conversation was about.
Also, on cross, there was discussion about whether he told the police certain things.
No, about the interview. Specifically, we asked, did you put this in your statement? He's referring to the 911 call, any 911 calls made prior to, you know.
See, I don't know that when the statement was made or when it was given, so I don't know. Of course, I only know what you are telling me or what's testified.
Well, then I guess can you clarify the question so we can determine whether you're referring to specifically the interview in which.
I can't hear you. Sorry.
I'm asking if he can restate the question so we can clarify if he's referring to the 911 call made, a 911 call made, or the police interview itself.
And I'm referring to the statements at the hotel. So,
Yes, during our cross-examination, we never asked a single question about any statements he made to the police at the hotel itself. So that is outside the scope of what he's able to ask in his redirect.
But there were questions about whether Mr. Bryant told the police everything about what happened.
And I can go a step further. We have body cam back, and that's the best evidence rule. We can watch exactly what Mr. Bryant did and not tell the police on the body cam.
If we're going into content, then yes.
Okay, so we're not gonna go into content?
I don't know.
Okay.
I just wanted to clarify that he did speak with police at the hotel, since it suggested that he did not call the police. Okay. Which has been asked and answered. Beyond that, I have no.
Okay, Mr. Bryant. Well, any questions based off of the redirect from anybody?
No, Your Honor.
Judge, I don't have a question, but I do have a request. When Mr. Bryant leaves out, can the court officers make sure him and his wife cannot speak? They don't have the opportunity to speak with each other. As soon as he leaves, she comes in.
Mr. Kirk, are you calling Ms. Coates?
Yes.
Okay.
Your Honor, while we're switching, may I make a call just to make sure someone's picking my son up since we're getting.
I had to make a call too.
Okay, thank you.
And use the restroom.
Okay.
So, but yes, to your request, to the officers, you want to make sure that Ms. Coates and.
Can they just be placed in different rooms?
I don't even know what room.
We'll do, Judge, take care of it.
Thank you.
And also, can you ensure you stay in the room so we make sure there's no text messaging between the two regarding the testimony and the attempt to get in line?
Only on the judge's order.
Judge, if you may, to ensure that these
Yes,
proceedings stay true.
yes, I want to ensure they're not communicating in between testimony.
You got it, Judge.
Thank you, Judge.
Okay, we're off the record. Okay, we're on the record as the people of the state of Michigan versus Justin Daniel Ringler and Israel Alondras Clary, case 2355496. Mr. Ringler and Clary are both charged with counts 1 and 2, robbery armed, and for count 3 and 4, committed 2 is charged with weapons felony firearm.
Good afternoon, Your Honor. Daniela Parrish on behalf of the people, P 85495.
Good afternoon, Your Honor. David Cripps, P 3497. On behalf of Justice Ringler, I would waive his appearance.
Okay, thank you.
Good afternoon, Your Honor. Jonathan Cohen, P 86151, appearing on behalf of Mr. Clary, who is in the hall, and I would also waive his appearance.
Okay. And I'm sure you all see what's going on in the courtroom. Things are just backed up. We're still holding testimony. Everyone wanted to hold today. I apologize. I thought we would have time to do. Everyone decided on a day that works for everyone.
Judge, what does the court's calendar look like for Monday? I have a trial, but I'm 90% sure it's going to set off tomorrow.
Monday and Tuesday, we both have 1:30 or the afternoon open.
The people, Your Honor, Monday would work, as I am in court, and the time is fine whenever it's good with the court.
That's fine with me.
I'm fine either day.
Okay, let's do Monday so Ms. Parrish can be here. I don't think she's on Tuesday. And she was closed.
If for some reason that 10% happens and I am stuck in trial, I'll let it go. And co
Okay, so we'll adjourn this to March 13th, Monday at 1:30 p.m.
Thank you.
Sorry about the inconvenience.
You don't need to apologize. I know how hard this court works.
Not your fault.
Thank you.
Yep.
Now we're off the record.
This chair reads me every time I put down. Scares me.
You already low to the ground.
I know, but to feel something moving, sometimes I forget to do my phone.
Okay, okay, so Judge, what's the best one? That's fine.
Okay, we're back on the record. This is case 22060378. People of the state of Michigan versus Kimberly Wilson, Victoria Wilson, and Laval Perkins. Appearances?
Alexander Kirker on behalf of the vehicle P86282.
Good afternoon, Carolina Sprinkle, P49898, on behalf of defendant number 4, LaValle Perkins.
And good afternoon, Tiffany Howe, P79667, on behalf of Victoria Wilson.
Good afternoon again, Your Honor. Leanna Belcher, P80177, on behalf of Ms. Kimberly Wilson, who's behind me. Ma'am, state your name.
Kimberly Wilson. Ms. Victoria Wilson. Okay, and Mr. Bryant is still in the box for testifying. Oh, is everyone done with Mr. Bryant's testimony?
Yes, Your Honor.
Okay, and. Okay, Mr. Bryant, you step down in the hallway. Officer Singleton,
Yes, Judge.
after Mr. Bryant leaves the courtroom, can you approach?
Yes, ma'am.
And can somebody make sure that Mr. Bryant doesn't speak to Ms. Coates in the hallway?
I'm so sorry, look at my heart.
Okay, now outside of the presence of any witnesses, there was sidebar discussion with all defense counsel as well as Mr. Kirker regarding Officer Singleton observing what may believe to be Ms. Alexandra Coates watching on YouTube the hearing today.
I believe so, Judge, but I'm not absolutely certain because
I'm gonna swear you in. Okay, swear to tell the truth, the whole truth, and nothing but the truth.
I do.
And can you state your name for the record?
Riley Singleton, court officer.
Okay, and what did you observe, if anything?
I heard the sounds from the courtroom coming from the room when I opened the door. I took her phone and she cleared off the screen. That was it.
And she was in the witness room by herself?
Correct.
Okay. All right, thank you.
You're welcome, man.
So now we need Ms. Coates, well, let me not call witness, excuse me. Mr. Kirker, do you plan on calling Ms. Coates?
I did not plan on calling this case.
Okay,
For the purposes of clearing this up.
yes. So Ms. Coates will come in for that purpose of seeing whether or not she's watching you.
Can she step out, Judge? I can waive her appearance for this testimony if needed. Okay, go ahead, baby. You can step out and waive her. Sorry, I should. The judge doesn't know when she
Let's
should
get
step
it.
out.
Ms. Coates, can you give your name to the court recorder? And then I'll swear you in.
Name is Aliyah Coates. ALEXANDRACOATS.
You swear to tell the truth, the whole truth, and nothing but the truth. This will be very short. Just have a seat here. Go to the front. Speak up. Okay, I'm gonna ask a question. You are not testifying today for anything that happened on this alleged incident. You're in here today because I am asking whether or not you viewed any of the court proceedings for this case while while you were waiting in the hallway or the witness?
What do you mean by that?
Were you watching on your phone?
Oh, no. No, it was no issue.
Okay. Is it true that Officer Singleton or the officer in the back there did take your phone?
Yes, ma'am.
Did you say anything?
I was asking what was going on, because I didn't know why he was taking my phone and why he made me out of the room.
Okay, so you never were on YouTube at any point watching testimony of Mr. Bryant W., your husband, right?
That's correct.
Any questions based off of what I asked? Anybody?
I have no question, Your Honor.
And Your Honor, my only question would be then if we have her phone, if she would consent to us looking at her browsing history on her phone?
Sure. That would be only consent. Sure. I'll let you do it and I'll watch you. I don't look at your phone. I really don't. Just for the record, Ms. Coates has her phone and I'm looking at her browsing history. For YouTube.
Judge, just for clarification, are we looking at the internet browser or the YouTube app?
So she just showed me all of her apps that are open, her internet browser, as well as her YouTube history. And her history has nothing to do with the court.
As well as the YouTube app?
Yes, it's an YouTube app. So, anything based off of what I just saw?
So, you say there's no indication that YouTube had been open? I was asking if are you saying that there's no indication that YouTube had been open? Because, you know, YouTube has its own library.
I could go
Right.
to my library and change my library too.
Sure. We were in the YouTube app and she showed me her history and everything that she searched. She said she opened her library as well. Her library, nothing to do with the work. Yeah, I don't see anything.
Okay, thank you, Judge.
Thank you. Ms. Combs, I appreciate you allowing us to do that. So Ms. Combs will not be called today for testimony, correct?
That's correct.
Okay, so you are all set, Ms. Combs? I'll step out. Thank you.
Next will still be separated, Judge, or still good?
At this point, I was thinking Madison. No.
No objection.
Okay, any witnesses for defense?
Not on behalf of Ms. Kimberly Wilson.
Not on behalf of Ms. Victoria Wilson.
No witnesses on behalf of Mr. Perkins.
Okay, Mr. Perkins.
This time the vehicle was moved to find over on count 1, robbery, arms, count 2, robbery, arms. What will be, and the additional counts of count 4, assault with intent to great bodily harm, and the additional count of count 5, assault with a dangerous weapon. And will reserve argument.
On behalf of Ms. Kimberly Wilson, I would object to the bind over. My client is charged in count 1, armed robbery as it relates to the larceny of the jacket. Count 2, armed robbery as it relates to the larceny of money and cell phone. And as well as count 3 for making an assault or assault and battery upon the following person, Alexandria Coates. That's obviously a misdemeanor. Judge, what I think is most important here is the witness's credibility. The court saw the video. I know the court can see clearly that Miss Kimberly Wilson was wearing extremely tight pink outfit. Mr. Bryant testified that she had a gun on her hip. She was swinging a knife. None of that was observed in the video, Your Honor. She did not have a weapon of any kind. At most, there was a disagreement that Mr. Bryant himself was a part of in shoving other individuals His wife willingly got in the car and left. He had an opportunity to call 911 if individuals, as he said, had a knife and a gun and a CPL and all this mess about weapons. He could call the police. Instead, he drives over to the residence, goes into a home where there's been a combative situation, according to him. He's been threatened with weapons, and he doesn't notify the police. Your Honor, quite simply, he's just not credible. The court could see how combative he was. It was painful to get the answers out of him, but he did not include anything that was relevant at the house in his statement about Miss Kimberly Wilson. The only thing that he finally admitted when I was questioning him was that the deceased defendant, LaToya, right, that was his name, was the one that hit him with the bat. There was nothing in there about my client hitting him with the bat, pulling out a gun, or the knife. But according to his testimony today, she had all three things, and how she was waving a bat and a knife and a gun when she only has two hands is just simply not credible, Judge. And for those reasons, I would ask this court to dismiss these charges.
Judge, on behalf of Victoria Wilson. First, the additional charges that prosecutor wanted to bind over were
Assault with intent to do great bodily harm and assault with dangerous weapon.
Well, who? I'm assuming Ms. Bryant.
Yes.
Okay, and Judge, my argument is the same as Attorney Belcher's. There's been no evidence on this record that would support any of these allegations made against any of the clients, but in particular, Ms. Victoria Wilson. There's been no testimony regarding any injuries sustained by Mr. Bryant, and the claims that he made that my client assaulted him, he specifically testified that Ms. Victoria Wilson was hitting him or swinging at him at the outside the hotel. Your Honor, swinging at someone, actually landing blows are two different things. There was no testimony. There was actually physical contact between my client's body and his. And more importantly, Your Honor, we saw the video. In the video, Mr. Bryant was, as Ms. Belcher said, engaging with all three ladies, including his wife, Your Honor, fighting all of them, arguing all of them. What we see Ms. Victoria Wilson doing is trying to break up any fights and disputes. You see her multiple times standing in between and placing herself between her cousin, Alexandria, and her husband, Your Honor. You see her trying to intervene on her sister's behalf, trying to break things out. And we also see break things up. And what we also see, we saw Mr. Bryant, after he had his coat, still engaging with the ladies. We see him after his wife made it clear that she wanted to leave her cousins with her coat, him trying to get in the car and take the jacket from his wife, Your Honor. Case law supports that this court, when considering buying over, should also consider credibility, Your Honor. And that is case People v. Anderson, that's 501 Bish 175 912 NW2D 503 2008 case, Your Honor. And in that case, the court has stated that credibility is relevant in when they're determining a testimony from a witness. And fortunately for my client and all the defendants here, we made a liar out of Mr. Bryant, a hostile liar. He went into a lot of exaggeration, and he told this court that he knew what he saw and he remembers, in the video contradicts of every stance. So we are asking for a dismissal on all counts, Judge.
What's the site for Anderson?
All right,
2008, right?
It's 2000, I'm sorry, it's 2018.
That's what, okay, I have
2018 case, in which the court made a decision. I think it's the Michigan Supreme Court regarding.
For the record, Charlotte Sprinkle on behalf of defendant Perkins. Your Honor, my client is charged in count 2, armed robbery, count 3, which is the misdemeanor assault and battery. We have the testimony of one defendant who testified very clearly that he was unable to see anything that took place outside with regard to his vehicle. So he was unable to place my client as one of the individuals who did anything to his vehicle. I would adopt the argument as to credibility that my sister councils have made, because I do recognize that there was his testimony claiming that Mr. Perkins came into the house from being outside and told him, I went in your car and took your things. So as to count 2, I would ask the court to deny bind over. Count 3 was a misdemeanor. I don't believe they made out that there was actually an assault and battery either. I'd ask for dismissal as to all counts as well.
Your Honor, just to clarify, on count 3, it's a misdemeanor of less than 2 years. Not need to prove that at this stage of the proceedings. As to the arguments, this was an incident that took place at 2 separate locations. It starts out at a hotel where initially the jacket was taken by Kimberly Wilson. The witness testified to, he stated that Kimberly Wilson did have a knife and gun, made threatening statements to him at this point, saying she would shoot him. Jack goes into the car, at some point it comes back out, it is then taken back into the car. We then saw from the video, his wife, the witness's wife, along with Kimberly and Victoria, leave the location and go to a separate location at Barnard Street. The witness then testified he received a call to come to that location to get his items and his wife back. At this point, he went there and he saw Kimberly, Victoria, Latoya, Lavelle, and another unknown male present at that location. On entering, Lavelle Perkins, defendant number 4, and an unknown male were standing by the only exit to the house with baseball bats. At some point, his wife came running up from the basement, and then she was beaten by Victoria and Kimberly in front of him while he was forced to sit in a chair. Eventually, he tries to jump up, but that's when he's hit in the head. This time, he says by Latoya Wilson about 15 to 20 times. At this point, then, Kimberly, Victoria, and Latoya say to run his pockets, which, as the witness said, meant to go through his items. And he stated that around $2,000 in cash was taken off of him. Kimberly Wilson then told Lavelle Perkins to go into the witness's car. From the car, the glove box was broken and around $200 to $300 in cash were taken from that. So the witness testified he did not get permission for anybody to take control of the other items. He was afraid for his life. And so we believe that we have met the burden of probable cause to find him. As to all.
Additional counts that you requested.
Yes, the two counts listed on the information, 2 counts of armed robbery and then 2 additional counts of assault with intent to create bodily harm and assault with intent. As to Derek Bryan.
I'm sorry.
As to Derek Bryan, the witness.
Okay, so without having to cite all the facts here, only question I believe is credibility at this point with Mr. Bryant. And I'm going to actually cite for people the answer. That in considering the credibility of witnesses, a magistrate, be it a district court judge in this case, may only decline to bind over a defendant if a witness's lack of credibility was considered together with the other evidence presented during the examination would preclude a person of ordinary prudence and caution from conscientiously entertaining plea of the accused guilt. I believe Mr. Bryant's a liar based off of what was said today versus what I saw in the video. And I don't like to use that word very lightly, but had that video not been played, the defendants would have been bound over with confidence. But after seeing that video, maybe I didn't see it, but I watched it very closely. I did not see a weapon. As Mr. Bryant was describing very in much detail with his gestures with Ms. Wilson, Victoria Wilson, having a knife in her hand in an upward and downward motion, swinging it in his face. I never saw that. I saw actually Ms. Wilson, Victoria Wilson, at one point protecting Mr. Bryant from getting beat up by his own wife, they were having a dispute on their own. And even when Mr. Bryant started off his discussion, it did seem, or his testimony, it did seem as if they were playing back and forth about the code. It was very confusing to me that this would lead to a gun being pointed at him and him having a knife pointed at him over a coat that his wife had, or he's giving to his wife on October 15th, even though he said it was for Valentine's Day. That was another point, which I just can't quite understand why you would celebrate Valentine's Day. I'm sorry, Mr. Kirsten.
Your Honor, it was for Sweetest Day, not Valentine's Day.
Oh, Sweetest Day, thank you. You said Valentine's. That makes sense. Celebrate Sweetest Day in the Midwest. Okay. But still, without having to talk about Sweetest Day and Valentine's Day, I do believe that after seeing the testimony or seeing the video, it is very hard for me to believe what Mr. Bryant has said for his testimony after that. At this level, I could try to pull together justification to bind over all the defendants. It would be a very weak case, even though it's a probable cause standard. I can look at credibility at this level, and I just believe that Mr. Bryant's lying. I think this is a family matter. I think that his wife had the issue. I think that it goes back and forth with his wife's family trying to protect her and trying to stay out of it. It's a hot mess with the family. And these are capital cases, and these are life-changing charges. And based off of what I saw in that video, I do not believe that he was robbed at the hotel. I don't think he was assaulted at the hotel at all in any way. It's the most contradictory testimony versus video I've seen in a while. So it's hard for me to believe what he's stating happened at the second location as well. So I'm going to dismiss without prejudice all counts. Still in court. So just to finish what I was saying, I'm dismissing without prejudice for insufficient evidence on all counts.
Thank you, Judge.
Your Honor, my client has a tether on. Or I think he was waiting for a tether, so that order is canceled.
Okay.
And my client does have a tether as well.
All we can.
Thank you.
I guess we just wait in the hallway to be a bit.
Go ahead and stand up, sir.
Okay, we are on the record on our last case for the day. People of the state of Michigan versus Javon Brandon Baxter, 2355408. Mr. Baxter is charged with 1 count of stolen property, receiving and concealing a motor vehicle set for a preliminary examination. Secretary.
Alexander Kirker on behalf of the vehicle P86282.
And good afternoon, Tiffany, on behalf of Mr. Baxter, P 79667. Mr. Baxter is present in court, standing behind you. State your name for the record.
Javon Brandon Baxter.
They are all parties ready to proceed.
People are not, Your Honor. Some of the witnesses are here, one of the witnesses is here, but the other necessary witness is not.
All right, this time we're asking for dismissal.
Okay, it's 3:38. Okay, dismiss without prejudice.
Thank you, Judge.
Have a great day. Work away.
Sure.
Have a great day. We're on the record. We're done for